Okay, good afternoon to you all. I think we have a few more people coming in. Amar is walking around. Those of you who are just coming in, fill out your little raffle ticket because we are going to do one more drawing today for a hotel room. And I think Sarah passed out, at least for those of you who are here, passed out all your little Starbucks cards, so we're good on that. Now, what we're going to do today, in approximately 4 hours, I can't possibly cover all the substance that you've already learned. The idea of today's session is to do overviews, and I've gotten requests from a lot of people. In fact, I was really scrambling to put stuff together yesterday based on requests that I got, which is being copied now, and so there's some more stuff that'll be coming. But it's kind of game plan approaches rather than a lot of detail. As we go along, I may stop and say, what about this subject? How are you? Is there something you want to focus on? Because we can't do every subject. And if, as we go along, if you have a question about something specific, you're welcome to ask it. If it's a question that's going to benefit everybody, I'll answer it. If it's a very specific question, then I may say, come see me on the break or see me after class, because, again, trying to kind of advance the process. So in the week, well, it's not even a whole week that's left before the exam. Wow, I know. We're going to start with the MBE subjects because they are the basis for a lot of Florida subjects. And I did have one request in con law, and so I'll stop when I get there for First Amendment. And I'm going to give you kind of an overview of how you approach an essay dealing with free speech. The religion clauses, obviously you got that material from Professor Kang, so I'll leave you to his material for religion clauses, but I've got a little outline, if you will, that you can use as a way to approach speech if it's in an essay question. So with that in mind, with constitutional law, remember kind of and how do you keep it all in your head? That's a lot of what we're going to be talking about today. With constitutional law, it's con law 1, con law 2, its powers, its rights. So dividing it up that way, which is how you learned it in the first place, a really good idea. All right, why is that not working? All right, and with powers in your brain again, distinguish between federal and state powers, and always consider what happens, of course, if you have a conflict. Separation of powers. As we go through, I do have a separate Florida con law outline, but I will from time to time try to point out some key differences. And you should all know by now that the U.S. Constitution has an implied separation of powers provision, but the Florida Constitution has an express provision. So anytime you can show when you're writing that Florida con law essay something that's uniquely Florida, you want to get it in there, of course, if it's relevant. If the question doesn't deal with separation of powers, don't throw it in. But they love to test it, so you get some extra points if you say Florida has an express separation of powers provision. Enumerated powers, Article 1, Section 8. I'm not going to go through them all now. Go through that list because you probably will have one question that on the MBE that deals with those enumerated powers. Retroactive legislation, something for both parts of the exam. Particularly contracts clause, of course. Florida's Constitution does prohibit ex post facto laws and bills of attainder as well, but what they like to test is contracts clause, which I'm sure you've seen as you've been practicing essays. So make sure that you understand and how they work, and unfortunately in this context, same rules whether it's MBE or Florida. Takings clause, we talked about last week, so I'm not going to go into that again. Remember, on a lot of those essays that we went through, if you take them apart and you look at the overall structure of what I did with them, that's your game plan if that subject is tested. So for takings, of course, you need the private property that's taken for a public purpose and with just compensation or full compensation if it's Florida. Elements, elements, elements. It's much easier for you to keep track of what's going on if you think about elements. And when you write it that way on the exam, it's a whole lot easier for the examiners to just go check, 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 check for the points. Executive powers, I'm going to kind of just leave that up there for a second, a little checklist there. That kind of detail will show up in multiple choice. It's unlikely to show up in an essay, even if they give you a federal constitutional essay, which they do occasionally. It's probably not going to be this stuff. But in multiple choice on the MBE, sure. So always keep track of those powers. Now, I did want to put the constitutional pyramid in. We forget, right? What's at the top of the constitutional pyramid? Guess what? U.S. Constitution. And remember I said federal versus state. You're going to have to look at conflicts sometimes. And of course, U.S. Constitution is the supreme law of the land, Supremacy Clause. Next level, treaties and federal statutes on a par. Last in time, of course, prevails. Executive orders a bump down from that, and then state and local laws. Always kind of keep that visual in mind when you get multiple choice questions dealing with that particular area. Some of the limits on the executive power, again, I'm not going to spend a lot of time talking about it now, but beware of it occasionally. Impeachment is probably the one that shows up the most, immunity from time to time as well. Now, judicial powers, the powers of the courts, federal court, Supreme Court, do spend a little bit of time looking at the jurisdiction of the courts, original jurisdiction of the Supreme Court, of course, and the jurisdiction of the federal courts. You'll see multiple choice questions dealing with that. Of course, when you get to Florida con law, they love to throw little jurisdictional questions into various essays. So even if it's not a Florida con law essay, you might have a little jurisdiction issue. Always, always, always be on the lookout for jurisdiction, because it is a favorite little testing tool. And even though it's oftentimes a small point, it's a point you get that other people don't get, and that's the name of the game. Threshold questions, absolutely. They love to test the threshold questions on the multiple choice. And as we saw last week with the Florida con law essay that we did, those threshold questions show up in Florida more often than you might think. And once again, it's not going to be the major issue in an essay, but it gets you extra points. So always look for your threshold questions. Limits on judicial power. 11th Amendment is something that, at least not real recently, but for a while there, the U.S. Supreme Court was dealing with 11th Amendment issues all the time. And so I'm sure you will get some questions dealing with 11th Amendment. Make sure that you know how that particular amendment works. Abstention and adequate independent state grounds. Those two things, they both start with A, but there's a big difference, because abstention, you're on the trial court level. Adequate and independent state grounds, you're going to be on an appeal level. So keeping those things straight, again, largely for multiple choice purposes. Supremacy Clause and preemption. Of course, you need to be on the lookout for preemption when it comes to multiple choice questions, whether it's express or implied preemption. Commerce Clause. Need I say more? What can I tell you? The Supreme Court doesn't use the Commerce Clause as much now as it once did. And so once upon a time, I'd just say, when in doubt, pick the Commerce Clause. It's not quite the rule anymore, but always be on the lookout for it. And obviously, when you're looking at Commerce Clause in particular, dormant or negative Commerce Clause is going to be the key. Now, individual rights, and here's where we're going to stop and do a little game plan, because I did get that request last week. Again, don't forget about standing, void for vagueness, overbreath, underbreath. Those are nice little things to throw into an essay, and whether it's federal con law or Florida con law. 13th Amendment, it's the one amendment that doesn't require, fill in the blank?
Government action.
State action, right? So remember that little testing trick. First Amendment, as I said before, you got a very complete lecture on the religion clauses from Professor Kang, and so I'm going to leave that aside. But let's take a look. The handouts aren't here yet, but let's do it anyway. They'll come. Because someone did say, well, if you get a First Amendment essay, what do you do? All right? You want to identify the type of speech and then the appropriate test. And that's, those are the two big issues, if you will, right? And now let's look at the types of speeches. And again, hopefully the handouts will be coming soon. So you've got pure speech, political or religious primarily. You've got commercial speech, and then I throw obscenity in, which of course isn't protected speech. It's unlikely you're going to see it in essay form. You could see it certainly in multiple choice. So identify what kind of speech you have first. Now, once you, and that's usually pretty easy, right? You can usually tell from the fact pattern. So we're going to assume now that our question is about political speech. If we're talking about political speech, or it could be religious speech, as opposed to the religion clauses, right? Most of the time, it's going to be a question about reasonable time, place, and manner restrictions. So what do you need to do? You got to identify the forum. Is it a public forum? Is it a non-public, semi-public, limited public, comes by different names forum, but make that distinction. If you have a public forum, you need to distinguish between regulations and injunctions, because the tests are a little bit different. If you're talking about a regulation, key is that the regulation has to be content neutral, which means that they can't be regulating based on the type of speech. It also has to be narrowly tailored to serve that important government interest and, of course, leave open the alternative means of communication. So again, if you're writing an essay, these are the steps that you're going to go through. If, of course, you have a public forum, what's a public forum? Courthouse steps, sidewalks, those traditional places where speech takes place. Now, if you are talking about an injunction, remember we're talking about speech, so the law is always a little suspect in respect to injunctions against speech. If you've got an injunction that's being issued, then it's got to serve a compelling state interest if it's based on content. And if it's content neutral, then still it's got to be, or not go any farther than it needs to serve that important government interest. I'm sorry? Gag orders? Yeah, gag orders, exactly right. When I say injunction here, it's injunction that prevents speech, yeah.
Would it make sense if one knows it to put in, like, the O'Brien test or Miller test or
if you know the names, that's fine, but don't just say the O'Brien test. You got to say what it's about, right? Because otherwise they don't know that you know it's the right test.
Is that also for prior restraints when they're trying to prevent you from speaking before you even do it?
Yeah, the injunctions. Now, if we're talking about limited, non-public, semi-public, goes by different names, really. Airports, schools, there are a lot of different cases that deal with this type of a forum. Not the courthouse steps, not where speech regularly takes place. Airport cases, think about all the Hare Krishna cases. In that case, if it is not a public forum, then we're talking about viewpoint neutral. Now, what's the difference between content neutral and viewpoint neutral? Content neutral says we can't discriminate on the type of speech, religious versus political versus whatever else. Viewpoint neutral says we can discriminate on the type of speech, but not the viewpoint of that type of speech. And of course, you have cases involving schools in which the court said that the school can prohibit any kind of discussion about abortion, but it can't just prohibit discussion that is pro or against abortion. And obviously, reasonably related to a legitimate government interest, a lesser level of scrutiny. Now, are there other speech issues that could come up? Sure. But this is the typical kind of question. If you've gone back and looked at the old questions, this is the type of stuff that they usually test. Okay, and as I said, if you have questions, pop in. If not, let's take a quick look at commercial speech. Honestly, they haven't tested it in essay form in a long time, but in case they do, you've got your 4 prongs from the Central Hudson case. Once again, I wouldn't just say Central Hudson. I would say, the case that, and then give the 4 prongs. So it's got to be truthful speech, right? And it's got to concern a lawful commercial activity, has to serve a substantial governmental interest, that kind of middle level of scrutiny, has to, of course, advance the interest and then be narrowly tailored. It is very definitely a middle level of scrutiny. Yes, sir?
For obscene speech, like the Miller test, is that like a balancing test, or is it?
It's all 3.
You need all 3 of them?
Yeah, you need all 3 for obscenity.
So they haven't tested that before? Or?
Not in essay form. Interesting. It'll come up in a multiple choice question possibly, but I've never seen it tested in essay form. Never say never when it comes to this exam. To me, it's unlikely in essay form, though. I'm going to go back 1. Commercial speech, yes. Okay, while I've got that up for people who are writing, any other questions there? Yes, sir?
Did you say that you were going to hand out these slides?
Yes. I got a lot of requests yesterday. And so while I was finishing grading my wills and trusts exam, I took all the ones that came in during the day, printed them out, and last night I put some slides together. Needless to say, and I got some more this morning, Sarah and Curleen didn't have an opportunity to make all the copies before class started. So I apologize for that, but I'm trying to respond to the questions I got from you guys. Okay, any other questions here? All right. The rest of, let's go back to con law. Sorry, that's wills. We don't need that. The rest of con law, not much more. Due process, equal protection. We talked about due process and equal protection. The key on that, on both of them. The good news is, whether you do a due process or an equal protection analysis on a fact pattern, you're going to come out in the same place. That's the good news. And honestly, it's tough to predict whether the Supreme Court is going to take due process, substantive due process, or equal protection. As you take a case like Moore versus the City of East Cleveland with the related family members who were living together, it sure looks like it's an equal protection case, and yet Marshall used substantive due process. So who knows? When in doubt, you could sort of put them both together. Most of the time, though, you're going to see a class which then will lead you, in an essay. It'll lead you, of course, to equal protection. Identify the class. What's the nature of the class? Is it just your regular garden variety economic class, or is it a suspect class or quasi-suspect, of which there really isn't much? And look for a fundamental right, which, of course, as we talked about last week in Florida, includes everything that's listed in the Florida Declaration of Rights. And if you've got either that suspect class or the fundamental right, you're at the highest level of scrutiny, strict scrutiny with the burden on the government. Middle level, you've got gender and commercial speech, and you've got, well, children of aliens in respect to education. You got that one little case, but mostly it's just gender and commercial speech in the middle, and then everything else is on the lowest level with the burden on the challenger. Yes, sir.
You mentioned the lecture from last week. Is that going to be posted this week?
Yes, I'm not sure what the holdup is because it got taped. That much I know. Then it's up to the library. I'll on the break I'll try to check. Usually they go up pretty quickly, so we'll try to get it up as fast as we can. Okay. One last area, privileges and immunities, but we've got a difference between the 14th Amendment and Article 4, Section 2. Make sure you distinguish. Particularly important for multiple choice, less likely to show up in essay form, to be honest. If you're talking about Article 4, Privileges and Immunities Clause, then the government of one state cannot deny to citizens of another state the privileges and immunities it affords to its own citizens. Privileges and immunities are not necessarily fundamental rights, because things like the right to work, which under the federal Constitution is not a fundamental right, is nevertheless protected under Article 4. So it's one state versus citizens of another state. When it comes to the 14th Amendment, privileges or immunities clause, then you're talking about a state in respect to its own citizens, and the state cannot deny its own citizens the privileges or immunities of national citizenship. So again, 14th Amendment, state versus its own citizens in respect to privileges or immunities of national citizenship. What do you want to look for there? The most important one, right to travel, right? Because that's the Sands case. It's the only one, quite frankly, that the Supreme Court has used under the 14th Amendment. So just look for right to travel. Anytime you have a residency requirement for something, think right to travel, fundamental right, 14th Amendment. With Article 4, privileges and immunities, about the two other things to remember. Corporations, not protected, right? You have to be a citizen, meaning a natural person, and the state participant exception that you have for the Commerce Clause state market participant exception does not apply to Article 4, privileges and immunities. Okay, anything in particular in con law that I didn't hit? I'm realizing again, I'm just, the idea is to get you all thinking. You should be filling in the blanks as I go along and saying, I know that area.
If we have a multiple choice question that gives you the Equal Protection Clause and the 14th Amendment privileges and immunities, we just assume, that the Equal Protection Clause would be a better answer?
Probably, unless it involves the right to travel, and then that's not a fair question. Because they're both, yeah. But see, that's the key. Yeah, right. But that's the key, because the Supreme Court has used this particular provision only in respect to the right to travel. Knowing the cases in con law, that's key. The more cases you know and you can recognize, the more questions you're going to get right. Other questions? Yes, sir.
When you say residency requirement, do you mean like you become a resident and have to wait longer or something? That
To get medical services or something like that.
14th Amendment.
Yeah.
What if it's in order to become a resident, they put more burden, like you need to live here a year to become a resident of the state?
To vote or?
Yeah.
Okay, anytime you have to live someplace for a while to exercise some kind of fundamental right, then you've got a right to travel issue. So if you, 14th Amendment. It's likely 14th Amendment. The question is, the Article 4 provision doesn't apply to corporations. 14th Amendment does. And you know that from equal protection, too. Although, I'll have to say, in respect to the article, the 14th Amendment Privileges or Immunities Clause, there's just that one case, and it didn't involve a corporation. So it's not likely to come up, honestly, on the exam. 14th Amendment equal protection very definitely includes corporations, though. Yes, sir.
Can you repeat what you were telling her about the residential duration?
Well, the idea is if you have to wait when you move to a state for fundamental services that residents don't have to wait for, then it's likely it infringes on the right to travel, which is a fundamental right. And that's the Sands case.
With regard to that fundamental right to travel, or right to travel under the 14th, would it apply if it's not, like if it's a federal right versus like a state, so like federal welfare versus like the residency requirement of a specific state for a specific
then
tuition program?
if they're not it depends on whether the state is denying its own residents that federal right. So I think that's all we really want to say there. Yes, ma'am.
Under the statute, when it says citizen,
Yes.
that means it doesn't include, the alien resident or
Right.
corporation.
Right. For Article 4. Yes. Correct. Okay. Other constitutional law questions. All right. Let's take a look now at contracts. Contracts, there's so much. So all I can do, once again, is kind of doing an overview, although I did, and thank you very much, Carrie, for being our delivery person today. I did get a request for a little discussion on third-party beneficiary and assignment and delegation. I'm going to do a little bit. I'm not going to go into a lot of detail because those rules get very complicated, but I have a couple of charts that are in this packet. So when we get there, once again, we'll stop and do a little more detail. All right, contracts. And of course, the good news about contracts is that whether you're writing an essay for Florida or dealing with the MBE, the rules are almost identical. There are a few little places we've talked about before. I'll point them out here. But the good news is, because there's enough to remember about contracts anyway. All right, so, and with contracts, what do you have to do? Follow this checklist. Whether you're answering a multiple choice question or you're writing an essay, follow this little checklist I have right here. You can maybe leave the Florida distinctions off, but there's your checklist. Any essay in contracts is going to follow that arc. And if you follow that arc, you will write an essay that'll get a really good score. I can promise you that, because people always come back and say, wow, I followed your advice and I got a really high score on my contracts essay. So first things first, by now, everybody knows you got to identify your governing law, right? Do it right at the beginning. And if you're reading a multiple choice question, identify your governing law right at the top, because you have to know whether you're applying common law or Article 2. Usually pretty easy to determine. Then you're going to look at contract formation, which has, of course, different rules depending on whether it's common law or Article 2. Then contract performance with breach and excuse issues, and finally remedies. There's one place on the exam, contracts, where remedies matter a whole lot. So let's take a look now at governing law. I think we've done enough, and you've done enough on whether it's Article 2 or common law. Just do yourselves a big favor. If you're writing an essay on contracts, then say what it is, not what it isn't. A lot of people start an essay and say, this particular question deals with the sale of land. Therefore, Article 2 does not apply. No. If it's the sale of land, the common law applies, right? So don't say what it isn't, say what it is. Formation. Elements of formation, make sure that you can spit them out. Now, if you're writing an essay, and they tell you that the contract has been formed, then don't spend a lot of time on formation. But oftentimes, formation is the biggest part of the question. And on the MBE, you know you have a lot of questions dealing with formation. So we're going to look at those elements of formation, defenses to enforcement and formation. Enforcement is the statute of frauds. Formation, other things like minority, mistake, fraud, those types of defenses. Make a distinction, enforcement versus formation. Again, you're picking up extra points that other people don't get. And then, of course, don't forget about estoppel, but never, ever start with estoppel. That's a first-year law student mistake, and you guys are way past that. Sometimes estoppel is important, but it's important only if the contract is not formed at law. Elements of formation. Goes without saying, offer, acceptance, consideration, right? Well, you got to be able to spit it out if you're writing an essay. You need to look for it if you're doing a multiple choice question. And of course, there's a lot that's involved, which I'm not going to go into unless I have a lot of questions, and then we'll see how detailed the questions are. But with your offer, of course, definite terms, right? For an offer, you need intent, definite terms, and communication to the offeree, whether it's common law or Article 2. The difference, of course, is that for Article 2, the one definite term is quantity, right? Now, with acceptance, first of all, you're going to get into the issue of whether it's an offer for a bilateral or a unilateral contract. And if you've got an essay and they give you a construction contract with bids, it's going to be an offer for a unilateral contract. Also with acceptance, mirror image rule versus 2207. I hate to tell you, they do like to test 2207 in essay form in Florida. And of course, you know you're going to get at least one question on the MBE dealing with 2207. So make sure that you can negotiate through 2207. Also, with offer and acceptance, you've spent a lot of time probably in your essays, if no place else, with option contracts and firm offers. They're different, right? Because the option contract is the common law rule, which you can also use under Article 2, and then a firm offer is the Article 2 rule. And always make that distinction in terms of acceptance. The key there is that whether it's an option contract or a firm offer, the acceptance has to be received within the option period, not just sent, but received within the option period. Consideration. It seems so easy, right? But it's not. And I bet as you do multiple choice questions, sometimes you get tripped up on consideration. So always remember, too, when you're writing about it in essay form, the consideration is almost always going to be in the mutual promises, not in the acts, unless it's an offer for a unilateral contract. But usually they're going to give you an offer for a bilateral contract. It's the promises. And under the MBE, you're going to use an and. Under Florida, an or, because Florida follows the first restatement. So benefit to the promisor, or, if you're in Florida, a detriment to the promisee. It's an and under the second restatement. But honestly, just focus on the detriment, because all the cases, whether they're Florida or MBE, focus on the detriment to the promisee. And make sure you identify consideration on both sides of the contract. I see a lot of people who look at just one side. Both promises have to be supported by consideration. If you get hung up on consideration, that's when you go to promissory estoppel and your three elements of estoppel. Estoppel comes in a couple of places, but that's the first place and the most likely place. That's Section 90, which you all learned in your contracts class. Three elements: you need that promise, you need the reliance that's actual and reasonable, and then, of course, reliance damages, which show the injustice that forms the basis of estoppel. You can also use estoppel, by the way, as an exception to the statute of frauds, which we'll get to in a moment. Those are the two main places where you're likely to see. It comes in also in another place, but they aren't likely to test it. Now, if you have what looks like a contract that has been formed, offer, acceptance, consideration, then stop and look at your defenses to formation. Don't leave the defenses, if you're writing an essay, all the way to the end of your answer, because at least these defenses say a contract was never formed in the first place. And there are, of course, many. Capacity, both parts of the exam, they love to test minors, so always be on the lookout. And in Florida, they don't tell you that the kid was 17 years old. They usually just say he's a high school student or something like that. Mistake of fact, here, of course, you're going to distinguish between mutual mistake and unilateral mistake. Ambiguity, misunderstanding, the ship's peerless, passing in the night. Fraud, the difference between fraud in the factum and fraud in the inducement. Duress, not very often, but every so often. Undue influence. Illegality. Keep all of those defenses, because the idea here is they're negating the formation of the contract. Statute of frauds is the defense to enforcement that you need to be familiar with. And when I read essays, I see a lot of errors in respect to what the statute of frauds means. The contract is formed as long as you have offer, acceptance, and consideration. What does the statute of frauds do? It tells you that the contract may not be enforced unless it's in writing. The statute of frauds does not make the contract. It simply tells you whether that contract can be enforced. You want to distinguish, of course, between the common law and Article 2. Article 2, it's $500 or more. Don't make the mistake of saying more than $500, particularly when it comes to the MBE, because if they give you a question with a contract for $500, you need the writing, right? And then for the common law, my legs, marriage, year, land, executors, goods, and sureties. There are some extra little ones in Florida. I'm not going to list them. I've never seen them tested, actually, but they're all those little ones with the newspaper subscriptions and home solicitation contracts, stuff like that. Now, if you need a writing, don't forget about exceptions. And again, you want to distinguish between common law and Article 2. Under the common law, two main exceptions, of course: part performance and promissory estoppel. Estoppel or estoppel, not just promissory, because it can be equitable estoppel also. Estoppel is a relative newcomer to the process. Part performance has been around for a long time. When it comes to Article 2, then first you've got the merchant's exception, right? You have to have two merchants, because it's as between merchants. So both parties, buyer and seller, have to be merchants. And also, that's where you have that 10-day rule that everybody confuses with 2207. Because if you've got that writing that's sent by one merchant to another merchant who has reason to know of the contents, then the receiving party has to respond within 10 days. Your other exceptions, 2201 subpart 3, specially manufactured goods, in admission in court, and part performance. But part performance only to the extent of goods delivered or payment received. Notice what's missing from that list under Article 2, promissory estoppel. And it's not clear whether estoppel is an exception to the statute of frauds under Article 2. So should you get it in essay form, and they do test it in essay form, then just say maybe yes, maybe no. Better rule is because. Parole evidence rule, I know. If there's anybody who wants to talk about parole evidence rule, I happen to like it, but Not within the context of this class. If you want to ask on the break or after class about parole evidence rule, I will be happy to chat with you about it. It's not the easiest thing, obviously. And the courts don't do a particularly good job of dealing with it. All right, now performance. Obviously, if the contract has been formed and you don't have defenses that are going to shut it down, then the next issue you have to talk about is performance. Depending on whether you've got common law or Article 2. If it's common law, that's where they're going to test conditions, and that's going to be particularly important on the MBE. So if you've got something particularly involving construction, that's where you're usually going to see your conditions in a construction or a service contract. Then that's going to be the question, was there performance? Conditions, you've got express conditions. I don't know if I have that here. Let's see. Nope. Okay. Express conditions, implied conditions, and constructive conditions. And of course, your conditions are precedent, concurrent, or subsequent. Well, make sure that you're looking for all of the above. With Article 2, of course, that's where you have the perfect tender rule. But along with the perfect tender rule is cure. They pair together because although Article 2 requires perfect tender, if perfect tender isn't made, then the seller gets the opportunity to cure, absolute right to cure before the time for performance, and a limited right to cure even after the time for performance. You don't really talk about cure, or you don't look for an answer choice if it's multiple choice, dealing with cure if it's a common law question. Conditions instead. Prospective inability to perform an anticipatory repudiation. They help you decide whether you have a breach before the due date. And you want to kind of start with prospective inability. In real life, you especially want to start there. The good news is the rules are going to be pretty much the same here, whether it's common law or Article 2. If you've got one party that probably won't perform on the due date, that's where prospective inability comes into play. So the contract has to be executory in respect to that person, and there's some suspicion that that person can't perform. That person has financial difficulties or is out of the country or something like that. Then what are you supposed to do? Demand reasonable assurances. And if you don't get the reasonable assurances within 30 days under Article 2 anyway, and you have to demand in writing under Article 2, maybe not under the common law, then you can treat the failure to give the assurances as an anticipatory repudiation and go right to anticipatory repudiation. Now, key, especially for multiple choice, when it comes to anticipatory repudiation, I see people missing this particular point all the time. The contract has to be executory on both sides, which means you have to have something left to do on both sides. If the non-breaching party is done performing, anticipatory repudiation is not available. And then, of course, you need that unequivocal, no, I will not perform, or the failure to give assurances after they've been properly requested. Then you've got the four possibilities. What can the non-breaching party do? Treat the contract as terminated and sue right away. Treat the repudiation as an offer to rescind, walk away from the contract. Suspend performance and wait until the due date, or ignore the repudiation and urge the breaching party to perform. Breach, about the only thing I want to say in terms of breach, you want to distinguish between, question, I'm sorry, Ben.
If for Article 2, is adequate assurances required by the non-breaching party? You have to ask for adequate assurances?
You have to ask.
You have to.
If
You can't do one of the four things?
Not if it's prospective inability. That's the difference. Okay? So if there is an absolute, unequivocal, no, I will not perform, then you can go right to the four remedies. The risk, though, is if you go right to the four remedies and you're wrong about it being an unequivocal repudiation, you've breached. So in real life, always safe to ask for the assurances. That's key. So if there's any doubt about whether that repudiation is an absolute repudiation, go to assurances first, which is what you're likely to see in essay form. Other questions on these two? They are favorite testing topics. Yes, ma'am.
For common law, do you have to wait 30 days also? Or reasonable time?
Yeah, reasonable time. Restatement doesn't require the writing or the 30 days. Okay, breach. Beyond anticipatory repudiation, just make sure you distinguish between a material breach and a non-material breach, right? Because a material breach allows the non-breaching party to suspend performance and sue right away. If it's a non-material breach or a minor breach, then you can sue, but you have to continue performance. Not a big player in terms of really either part of the exam. Risk of loss, though, is. And risk of loss, particularly in the context of Article 2. It can be an issue, of course, under the common law, particularly if it's a sale of real property, right? And then you talk about equitable conversion versus the Uniform Vendor and Purchaser Risk Act. But here, what we really want to talk about is risk of loss under Article 2. So that's risk of loss when the goods are destroyed in transit through no fault of either of the parties. You want to distinguish first based on who's doing the transporting. If, which is the usual case, the parties contract for a third party to transport the goods, then ask whether it's FOB, seller's place of business, or FOB, buyer's place of business. If it's FOB, seller's place of business, which is the usual form, that's a shipment contract, which is the preferred form. Risk of loss transfers from seller to buyer as soon as the goods are placed on the truck or whatever it is, truck, train, whatever, ship. If it's FOB, buyer's place of business, then the risk remains on the seller until the goods reach the buyer. Warehouse cases, that's your second category. In the warehouse cases, the risk shifts when notice is given to the buyer. And then third category, in your non-carrier cases, the risk is going to remain on the seller until the goods reach the buyer. If the seller is a merchant, then the goods have to actually be placed in the buyer's hands. If the seller is not a merchant, then the seller just has to tender delivery. Okay. Yes, sir.
What was your reference to warehouse?
If you have goods that are stored in a warehouse, that's the second category of risk of loss. There's a real famous case with an opinion by Judge Posner involving ribs, pork ribs, and they were being stored in a warehouse that both the buyer and the seller had goods in. So what happened is, or what would normally happen is, when the goods were sold from seller to buyer, you just do a book transfer, and the goods would be transferred without being moved. In this particular case, somewhere, and they weren't exactly sure when, sometime around the time that the book transfer was made, the warehouse caught fire and the ribs were very crispy. And so the question was, who had the risk of loss? And the seller said, well, we knew that the book transfer had taken place. That's good enough because Article 2 doesn't actually say to whom the notice is supposed to be given. But Posner said no. Risk of loss transfers to the buyer when the buyer gets notice of the book transfer.
There was something else I can't remember that goes with this FOB thing that was like courier, freight, insured or something. It was
CIF, cost, insurance, and freight. Usually with the CIF contract, the risk of loss will shift to the buyer on delivery to the courier, to the truck, to the ship, to the whoever's transporting the goods. Again, CIF is going to be a third-party carrier.
This might be like over
Oh, under Article 2, the preference is for a shipment contract, which means the goods, the risks shift from the seller to the buyer as soon as the goods are delivered to the truck, to the transporter, to the carrier. That is your presumption, yes. Other questions? It's an area that they do like to test. It could, I haven't seen it so much in essay form, although it could, but they like to test it on the MBE. Now, next area, excuse from performance. You need to know impossibility, impracticability, frustration of purpose, because it shows up on both parts of the exam a lot. Impossibility, impracticability, frustration of purpose. Impossibility and impracticability are seller's excuses, or if it's common law, the person who's providing the service. If you're talking about frustration of purpose, that's the buyer's excuse or the person receiving the service. That's the coronation case, Krell versus Henry, the guy that rented the room to see the procession, the king's coronation procession, and he got appendicitis, and so they postponed the procession. So, 4 steps if you're talking about excuse from performance. First thing you want to do, and again, the good news is common law, Article 2, it's going to be the same. Florida, it's going to be the same. First thing to look for is a force majeure clause, a clause that reassigns the risk of loss. If you have a force majeure clause, just apply it. You may see a force majeure clause on the MBE. I've never seen it on the Florida portion. Force majeure? Force majeure says who bears the risk of loss in the event of hurricane, rainstorm, thunderstorm, all those nasty things, strikes, all that stuff.
When they have it, it'll be there.
Yes. Yeah, if you can have a multiple choice question that has a force majeure clause built into it. If you have a clause who says who bears the risk of loss in the event that performance is prevented due to a thunderstorm, a hurricane, a snowstorm, a strike, a whatever, then just apply the provisions that are there, because it'll tell you what to do. Again, MBE is where you're more likely to see that. In the absence of a force majeure clause, then you look for that unforeseen event. The hard freeze in Florida, maybe. We did that essay question with the freeze in Plant City. So that's an unforeseen event. That makes performance impossible, impracticable, or it frustrates the purpose. Now, what makes performance impossible? Remember, it has to be objective impossibility. What are they likely to test there? Whichever part of the exam? Crops and a failure of a crop. If the promise is to sell, as we saw in the question we did, 100 pounds of strawberries, then even if the seller's crop is destroyed, you do not have objective impossibility, because the seller can just go out and buy them someplace else. If the seller says, my 100 pounds of strawberries from my strawberry patch, now you have objective impossibility. So, destruction of the subject matter on an objective basis or death of the promisor. Those are the 2 things that you look for with impossibility. Yes, sir?
Death of the promisor only if it's like his services are special or whatever.
Well, right. And impracticability means it's not just really hard. It's got to be extremely expensive. The first restatement said a 10-fold increase in price. A lot. There are a bunch of Suez Canal closing cases in which a doubling or tripling of the price was not enough. So it's got to be extremely expensive, and there's got to be risk to person or property. So somebody's going to die, or property is going to be lost. It's a rare case in which impracticability is actually going to be a good excuse. Now, frustration of purpose, again, coronation case is the best way to remember frustration of purpose. Could the guy who rented the room pay for it? Sure. But what was the point? Because he didn't get to see the procession. Now, fourth element, though, don't forget about. The person who is seeking excuse based on this unforeseen event cannot be at fault. So you can't burn your house down and then say, oops, I have no house left to perform, or whatever, or burn your crop and say I have no crop. So it can't be your fault if you're seeking excuse.
Even if it's like a negligent fault?
It's still your fault. If negligence, you would not be able to use the excuse, yeah. Yes, sir.
Your excusal, it's not a breach of the
Right. If you have, yes, if you have a valid excuse, it's not a breach. And both parties then will have performance suspended. Because, of course, if one party is excused, the other party doesn't have to perform either. Okay, other questions about excuse? Warranties. Express warranties, implied warranties. Certainly can be tested on both parts of the exam. And with warranties, it's not just a contracts issue when you get to the essays, right? Because if you have a products liability question, make sure you look for warranties. So, express warranties. An express warranty is just that affirmation of fact that becomes part of the basis of the bargain. Any description, any sample, any model, anything you say, just the color of the item, that's enough to have an express warranty. Implied warranties, there are two. First is implied warranty of merchantability. Now, you need a merchant seller, and it's a merchant who deals in goods of the kind, a goods merchant. And that implied warranty of merchantability says the goods are fit for the ordinary purpose. If it's an implied warranty of fitness for a particular purpose, then any seller, not just a merchant seller, any seller can make that warranty. The buyer has to make known to the seller the buyer's particular purpose. And then the seller has to know the buyer is relying on the seller's skill or judgment in selecting the goods. Then we're looking for a particular purpose. Yes, somebody had a hand up. Yeah.
You know those warranties come up in tort liability.
Yep.
In contracts, doesn't it say like the warranties are limited? The liability for the warranty is limited to the cost of the product.
It can, if I understand where you're heading, it has to do with remedy. You can have a limited remedy. You can have a disclaimer of the warranty, but the issue may be in terms of remedy for injury to person. That you can't disclaim. So that's your tort issue, really, right?
Okay, so they would be liable for the resulting injury.
Right. Yeah, so for the economic loss to the property itself, no liability, but the injury to the person, yes. Other questions on warranties? Yes, sir.
I have a question about the conditions.
Okay, okay.
So one of the Article 2 conditions you referred to as the perfect tender rule.
Well, it's not a condition, it's just a perfect tender rule, right? You're going to go down one of two paths when you get to performance. Either the common law, which is going to talk about conditions, or Article 2, which talks about perfect tender.
So, but my question is, if you use the shipment of goods as an acceptance of an offer, and then you ship non-conforming.
If it's shipped as an accommodation, it's an acceptance and a breach. So if somebody makes offers to buy, I don't know, 100 pounds of or 100 bottles of Zephyr Hills water, and you don't have 100 bottles of Zephyr Hills water, but you ship as an accommodation, and you say you're shipping as an accommodation. You say, I don't have 100 bottles of Zephyr Hills water, but I have 100 bottles of Aquafina water. That's an accommodation, right? It's an acceptance, but it's also a breach. Now, there may not be any damages if the bottles of water are functional equivalents, but it's still a breach.
I guess what I was going to ask was, do you have the same like recourse where you can accept all of it, reject a commercial unit and all that?
Yes, right.
When it's under performance, or when it's under, you ship it as the acceptance of the offer.
Right. If you ship it, then it's still a non-conforming shipment, right? So it could be rejected. Yeah.
I'm sorry, I thought that when you send something as an accommodation, it's a kind of offer.
Exactly. That's why it can be.
So it's not an acceptance and a breach.
Well, it's an offer, but yeah.
Because you can accept them.
You can accept them or you can reject them, but if they're accepted, I guess, then it's. Yeah, let's see if I can say that right. And I got to scroll back in my brain on that one. Give me a second to go back in the steps on that one, but I'll get back to that one.
I guess it's almost following up that. Does it matter if the accommodation is sent with a letter or not?
You have to say it's.
As to, like, say.
Okay, you have to say it's an accommodation.
Right. Well, I mean, doesn't it have certain requirements?
Okay, let's do this, if we could, on the accommodation, because I got to think back in my brain, honestly, on that. Give me a few moments to think about it. I may want to look at my notes, but I'll go back and take a look. When we come back after a break, I'll make sure that I make that statement clear for you. Okay? Sometimes when I'm going like this, and a lot of stuff is going on in my brain, I have to slow down a moment to make sure I give you the right rule. I'll get back to you, and after the break, we'll make sure we clear that one up. Okay, other questions, though, at this point? All right. Breach, we kind of talked about that, so we don't need it anymore. We did risk of loss and that. Okay, remedies. I am not going to go through every remedy under Article 2, every remedy under the common law. But make sure, especially when it comes to the Article 2 remedies under Article 2, make sure that you distinguish between buyer remedies and seller remedies. Because there's a difference, and the vocabulary matters. And remember that the buyer covers, but the seller resells. Those little things in the multiple choice questions are very important. And when it comes to remedies, you're always looking at contract remedies. You're looking at the difference between two things, plus something, less something. Difference between contract price and market price, for example. Plus incidental damages, plus consequential damages if you're the buyer, but always less expenses saved. So it's just a really basic formula. Question? No? Okay. So difference between something and something, contract price, market price, or contract price, cover price, or contract price, resale price. That's your basic measure. Plus, always plus incidental damages, whether you're buyer or seller. Plus consequentials if you're the buyer, but not the seller, unless you're a loss volume seller. And then always less expenses saved. Yes, sir?
Something about performance and breach. It says like you can't sue from a breach when there's been full performance, but if there is a breach, then how could there be full performance? Like if you finish 99%, if there is a material or minor breach.
Okay, that's a different issue. Okay, that's peculiar to construction contracts. All right, and it deals with when do you have substantial performance under a construction contract. Remember that if, again, you're in the common law, so you've got to reach a minimum to have performed, or else you're in total breach. And that minimum is substantial performance. How much is substantial performance in construction contracts? It's generally 90%. So if your contractor has not even reached the 90% rate, then the contractor is in total breach, right? If the contractors reach 90%, then it's considered to be substantial performance, but you still may have damages for the difference between the 90% and the 100%. Remember also, which kind of takes you into quasi-contract too, because if you haven't reached the 90% rate, then your only possibility as the contractor is to recover in quasi-contract. But then you have to distinguish between building something new and doing work on something existing. Because if, for example, and the typical question is going to be, you're building something new, you get to 50% and the thing is destroyed, you got to start all over again. You can't recover in quasi-contract. If you're doing work on an existing structure, then if you haven't gotten to the substantial performance level, which would then allow you to recover on the contract, then you can still recover in quasi-contract. So again, new building, destroyed, start all over again. No remedy at all in quasi-contract. Existing building, you can recover in quasi-contract. I think that's your question? Yeah? Okay.
In new construction, home, if the buyer or owner repudiates during construction, have a tough time measuring
Yeah, you know, I have, there's a lot of detail that goes into the measure of damages, and I have slides which maybe later on, for those who want to look at them, I can put up, because there are several different measures in construction contracts that are used. They usually come out basically the same. You're trying to get the benefit of the bargain, but there are different ways to do it. So what I would rather do on that particular point, because it's a lot of detail, is, again, you know, I can show it to people a little bit later on if anybody wants to hang around for that one. Okay. We need to remember your basic measure of damages in contracts. Expectation, which puts the non-breaching party where he or she would have been if the contract had been performed. Then you've got reliance damages, and as we started to talk about, restitutionary damages in the form of quasi-contract. You're not going to have both expectation and reliance in most cases. I'm not going to say never, because actually I've read some cases where they do kind of give both. You're not supposed to. It's one or the other. And for those of you that read the Red Owl case in your contracts class, some did, some didn't, Red Owl versus Hoffman, then you'll know that reliance damages should never exceed expectation damages. On the other hand, restitutionary damages can be as large as they need to be. They can actually exceed expectation damages. Now, what's the difference between reliance and restitution? I see a lot of people struggle with that, and it's very easy to test. Reliance damages, you're out of pocket that you paid to somebody else in reliance on the other person's promise. Restitution is you get restitution for the benefit you've conferred on the other person, to avoid, of course, unjust enrichment. Consequential damages I want to mention, and then my brain scrolled back to the accommodation, so I'll pick that up again because I know where I was going a little bit astray in what I explained to you. But let's do consequential damages first. Consequential damages: foreseeable, unavoidable, ascertainable. Those three things. There is not this overwhelming requirement to mitigate in the context of contracts in general. There are certain places where mitigation is required, and here's one of them. So for your consequential damages, lost profits usually. Foreseeability, that's Hadley versus Baxendale. Unavoidability, that's your mitigation. And then ascertainable, just have to be able to quantify. Now, on the other issue we were talking about, let me just get it out there and so we can move past it. If you, going back to the bottles of water, that Josh is shipping to me. If he just ships me the Aquafina, that's an acceptance on his part and a breach at the same time. If he tells me it's an accommodation, then that's the offer. So I do apologize. I say my brain just went a little too fast there.
In that situation, you can only reject all or accept all. You can't.
Right.
You don't have this kind of.
Okay. So I do apologize, but that's, once again, if Josh doesn't have, what was it, Zephyr Hill, thanks. Josh doesn't have Zephyr Hill, and he just sends me Aquafina, it's an acceptance and a breach. If he tells me it's an accommodation, then that's an offer. So I do apologize.
Do you have to have money allowances with that? With the accommodation?
You don't have to, you could, is the answer. And usually, and money allowances, you tend to see money allowances in the context of cure. Because if you have a cure that's offered after the due date, then the cure is a reasonable cure, including with money allowances. So could you have it with accommodation? Yeah, you could too.
If you accept the accommodation, that's the contract price.
Yes.
Even though the goods may be
Right, because it's an offer and you've accepted the new offer. So maybe I decide Aquafina, I like it, I'll take it. But you could have a money allowance because I have no idea, honestly, if they're priced differently, but they might be.
There's a written contract, though, and there's an accommodation. It doesn't change the original accommodation.
Well, that you don't have a contract if it's shipped as because remember, there's an offer. And now it's a counter offer. Yeah, exactly. You got it?
No. So when I send the notice of accommodation, it has to be written, right? Mm-hmm. It's considered a counteroffer.
It's a counteroffer,
An
right?
acceptance and a breach at the same time?
No. The acceptance and a breach is if you send it without the notice of accommodation.
Okay, got it.
Okay? Okay, the question, mitigation. Okay, are we done with accommodation, by the way? Okay, let's go back to mitigation, because it's an important point. I see a lot of people writing in all contracts questions, oh, there's a duty to mitigate. Not true. And think about Article 2, because the non-breaching party, for example, suppose that the seller breaches. So Josh is the seller. And he doesn't send me my 100 bottles of Zephyr Hills. He doesn't send me anything. He's breached. I get options under Article 2. I can go out and cover if I want. But maybe I don't want to. I don't have to. The cover would be kind of like mitigation. I don't have to. I can sue him for the difference between the contract price and the market price. So that there is not an overriding duty to mitigate. Now, if the buyer is the one who's suing, I might have made a lot of money on Zephyr Hills. Who knows? Can I sue him for lost profits? Yes, if I satisfy these 3 requirements. And mitigation in the form of unavoidability is one of those requirements. But do I have to go out, if I'm just suing for the basic measure, do I have to go out and buy bottles of water? The answer is no. When is mitigation an important issue, though, in terms of damages? Employment contracts. Oh, wow. Because if you have an employee who is going to sue the employer, then the employee has to attempt to mitigate by finding another position, right? There you go. That's the difference. Okay, so we're going to go. Okay, assignments and delegations. There, it's in the extra handout that Carrie delivered for you. And it's just a little drawing. Someone asked if I could review assignments and delegations and third-party beneficiary. I'm going to do a little bit, not a lot, because it's both of them are really complicated subjects. Someplace in there, in the new one, you've got the last page. Okay. Oh, it could be in the contracts one, too. Okay. All right, so for assignments and delegation, let's start there first. Vocabulary, vocabulary, vocabulary. You've got your obligor and your obligee. The obligor is the one who's supposed to do something under the contract. The obligee is the one who gets the benefit, right? And you've got that underlying contract. The obligee may become an assignor by assigning the rights to the assignee. Most rights are assignable, right? Unless the assignment materially changes the duty of the obligor. It's the exception, not the rule. And if you have a clause in a contract that prohibits assignments, and yet an assignment takes place, an assignment of rights, you assign rights, you delegate duties, vocabulary again. Very important for both parts of the exam. If that clause prohibits an assignment, the assignment is still valid. The assignment of the rights is still valid, but it's a breach of contract. Different for delegation of duties, but assignment of rights, the assignment is still valid. And of course, on the other side, we have the delegation of the duty. Duties can be delegated unless, of course, you have a contractual prohibition, or you have a statutory prohibition, or if there's a material change in the benefit that the obligee will receive. Now, sometimes the question of vesting comes up in this context. Vesting in the context of assignments and delegations is different from vesting in third-party beneficiary. When do the rights of the assignee vest? On notice to the obligor. So, if you have that assignment, the obligor can continue and really should continue performing for the benefit of the obligee unless and until somebody, probably the assignee, gives notice to the obligor of the assignment. Once that notice is given, of course, then the obligor has to perform directly to the assignee. Now, oftentimes the question comes, can the obligee or the assignee of the obligee sue the delegatee? And the answer, of course, is yes, but you may have an issue of defenses, which is where we now turn to third-party beneficiary. So before I turn to third-party beneficiary, questions up to this point? Yes, sir?
Are you going to discuss the liability of each party to everybody after you do that?
Well, that's the third-party beneficiary drawing, to be honest, because what happens is that you take this part of the drawing and you fold it up and make a third-party beneficiary triangle. So when your assignee or your obligee is suing either, well, back up. If your obligee is suing the obligor, they're just suing on the contract, right? If the assignee is suing the obligor, or the assignee or obligee is suing the delegatee, that's when you start to use a third-party beneficiary analysis. You switch from assignments and delegation right over to third-party beneficiary.
That third-party beneficiary analysis, would that only happen if the rights are vested? Like if notice is given to the obligor, you know, the assignment, that's when you would kind of go to the third-party.
That is correct, right. Because up until that time, the obligor is free to and probably should still keep performing to the obligee. So the vesting then switches you over, especially if you're assignee. And your assignee is going to be up there in the position of the beneficiary, suing the delegatee over here. So in a third-party beneficiary situation, again, either you've just taken that assignment and delegation chart and bent this half up like that, or you have a traditional third-party beneficiary situation. Base of the triangle, your promisor and promisee. And sorry that the vocabulary is different, but what can I tell you? I didn't make it up. The promisor is going to be your defendant. The promisee is the person who extracts a promise from the promisor for the benefit of the beneficiary. Establish the base of the triangle first. You must have an enforceable contract at the base of the triangle. That's what these arrows are. You have to have consideration going both ways. And then the side of the triangle is the connection between the promisee and the beneficiary. If you have a creditor beneficiary, then you've got a contract on that side as well. If it's a donee beneficiary, then it's just intent. Once again, the promisee extracts a promise from the promisor to benefit the beneficiary. Now, if your beneficiary sues the promisor, the question becomes, well, first of all, can the beneficiary sue the promisor? Yes, assuming that the beneficiary is an intended third-party beneficiary, creditor beneficiary, or donee beneficiary. The question will become, can the promisor assert defenses against the beneficiary? We start with the base of the triangle. The promisor can assert against the beneficiary any defenses that the promisor could assert against the promisee. Mistake, fraud, capacity, any of those defenses. Lack of consideration, any of those defenses. Can the promisor assert against the beneficiary defenses that the promisee has against the beneficiary? Well, if the beneficiary is a donee beneficiary, there are no defenses, right? That one's easy. If the beneficiary is a creditor beneficiary, then you have to ask, what was the nature of the promise? If your promisor promises to pay to the beneficiary whatever the promisee owes to the beneficiary, then any defenses that might exist between promisee and beneficiary may be asserted by the promisor against the beneficiary, because they're going to affect how much is owed. If, on the other hand, promisor just promises to pay a set sum of money to the beneficiary, then defenses from this side of the triangle cannot be asserted because it's just a promise to pay money. Can your promisee sue the promisor? Under modern law, the answer is yes, whether your beneficiary is a creditor beneficiary or a donee beneficiary. That's a change from traditional common law, because traditional common law said no if your beneficiary is a donee beneficiary. But if the promisee is suing the promisor, remedy may be an issue. And if your beneficiary is a donee beneficiary, then the only remedy the promisee can get is injunctive relief. Final question is, can the base of the triangle, this relationship between promisee and promisor, can it be changed? It can be changed up until the time that the rights of the beneficiary vest. When do the rights of the beneficiary vest? Notice to the beneficiary, beneficiary brings suit, or changes position in reliance. And that's probably all you need to know about third-party beneficiary.
The beneficiary can go against the promisee.
Oh, I'm sorry. Can the beneficiary sue the promisee? Good question. Sorry, forgot about that one. The beneficiary can sue the promisee if the beneficiary is a creditor beneficiary, but not a donee beneficiary. Absolutely correct.
So just to understand how you brought in the assignment and delegating chart
Yep.
of that. So first you should kind of just see the relationship, whether rights or duties were assigned or delegated, and then you kind of change the name of the parties such
Yeah.
that it goes in conjunction with the third
Right.
party
What we
beneficiary.
do is we put a break right here in the line, and we take this part of the line and we fold it up. And your obligee will now be the promisee. Your assignee will now be the third-party beneficiary. So once again, just to explain it, you fold right here. Obligee becomes promisee, and assignee becomes beneficiary. And then you use the analysis I just gave you for third-party beneficiary.
I don't forget the language. Is it okay if you just kind of like describe
Oh,
what
yeah.
the person is? in an essay?
The question is,
I don't know the
right, if you have an essay, and unfortunately, they have tested third-party beneficiaries in essay form in Florida. Do the best you can with vocabulary. But for the MBE, try to keep these distinctions in mind, because you could get a multiple choice question where they give you the right concept but with the wrong terminology. And should they be that picky? Maybe not, but are they that picky? Yes. It's just like the difference between cover and resale. That's how they get you. So try to keep those terms in mind if you can. If you're writing in an essay form, describe it as best you can. Question?
Okay, is the obligor becomes the promisor?
Yes. Exactly right. The obligor or the delegatee, if you have a delegatee, becomes the promisor.
Now, you mentioned about the clause prohibiting assignments and what that would do would still be a valid assignment, but it would be a breach of contract.
Yep.
What about a clause prohibiting a delegation?
That's enforced as written. If you have a contract clause that prohibits delegation, then the delegation's improper.
So there's multiple choice questions that are like, does this person have to accept
Right.
services or duties?
Right. And if there's a clause that prohibits delegation, the answer is no.
He doesn't have to accept.
Doesn't have to accept. Yep.
Thank you.
I just couldn't. Oh, the question is, does your third-party beneficiary have privity of contract? And the answer is, not in my book. Let's go back to that picture and I'll explain why. The beneficiary, the third-party beneficiary, is not in privity of contract with the promisor, not traditional privity of contract, because there's no relationship between the two of them. But can the beneficiary sue the promisor? Yes, and it's, I like to say it's third-party beneficiary liability rather than privity of contract, because true privity of contract doesn't exist.
So promisor could use the vectors that you have in this promisee.
Yes, absolutely.
Could beneficiary argue like promisee's contractual or promisor's contractual duties to the promisee? Now, like, could beneficiary put himself in the shoes of the promisee and argue the defenses?
Oh, sure. Right. Yeah, absolutely. Okay. Anything else about contracts? So we spent quite a bit of time on contracts. It's that kind of subject. All right. Let's leave it aside. Now, going in alphabetical order, the next topic would be criminal law, criminal procedure. I can certainly take some time to talk about them briefly. Is there anybody who has a burning desire to do anything in great detail in either one of those? All right, let me just do an overview. If I trigger questions, feel free to ask. But because we've got so much, and somebody asked, for example, about character evidence. Yeah. The reason I say, you'll see why I say that. I hate the way people teach character evidence, because there's a better way to do it. But
For juvenile delinquency, I did Venus, and they really have been testing a lot. I wanted to know what you thought I know it's a new subject, right?
I don't know how they're going to test delinquency. It could be multiple choice. It could be essay. It's anybody's guess if it shows up.
How far in depth would you go into wasting time on study?
I hate.
Seriously,
Yeah.
because it's so.
I know.
So fact
I hate to say I don't know, but I really don't on that particular one because nobody tests it. So we can't even look to other states. When we talk about commercial paper and secured trans, we at least know how it's been tested other places and secured trans tested here. Delinquency, I don't have a clue. All I can tell you is know something, I guess. I hate to say that. Not a great answer, but that's the best I can do there. All right, let's take a very quick stroll. Okay, thank you very much. We'll take a break soon because I know you're getting tired. But let's go ahead and get these out of the way. Question?
Can you discuss the 4 types of insanity?
Yeah, actually, yeah. You know what? If I don't have the slide up here, I have a slide and I'll pull it up after the break. Okay. So let's talk briefly again about criminal law, criminal procedure, because I want to get on to some of the other stuff that you've asked about. And the question was about insanity, the 4 tests. I do have a slide that I don't think I have in the material here that I'll pull up after the break so you can take a look at that. Because you are probably going to see on the MBE, you will see a question that deals with, at least one dealing with insanity. Now, I threw this slide in. You actually don't have it. That's something I added in just in case you see criminal law in essay form. Probably you won't, but if you do, remember to just march through the elements of the crime. All crimes kind of have the same formula, if you will. The actus reus, the mens rea, tenant circumstances, causation, and concurrence. So it gives you a formula in the event that you get an essay or a component of an essay dealing with a crime. Florida has not tested criminal law as a standalone essay in many, many years. They almost certainly will not, but they do throw crimes in as components in other essays, torts in particular. Now, with the actus reus, that's the thing that's done. If it's larceny, for example, it's the taking and carrying away, right? If it's homicide, it's killing somebody. So whatever act, focus on that. Mens rea, I do want to take a few minutes to talk about. Distinguishing between common law and model penal code. The reason that I want to make the distinction is probably for most of you, when you had your criminal law class, you learned model penal code. And you may not have learned very much about the common law. What do they test on this exam? Mostly the common law. I guess because they know everybody covers model penal code these days. So common law, what can I tell you? 3 levels of intent. Specific intent, malice, and general intent. General intent is your catch-all. If a crime is not specific intent or malice, it's general intent. Malice crimes, there are only a few malice crimes, kind of carved out from the specific intent crimes. The ones you want to focus on, common law murder and arson. Those are and then mayhem, bodily dismemberment, is the 3rd one. You're not going to get tested on that. But arson and malice, yes. Arson and homicide, yes. Specific intent crimes. You have to have the intent to achieve the result. Not just to do the act, but to achieve the result. Specific intent crimes. All of the theft crimes. So we're talking about larceny, robbery, false pretenses, burglary, that's habitat, but it's still specific intent. Receiving stolen property, probably. All of those theft crimes. Also, all of the inchoate crimes, solicitation, attempt, and conspiracy. And then first degree murder, premeditated, deliberated, which isn't really a common law crime. So all of your theft crimes, all inchoate crimes, and first degree murder. That's what goes into this category of specific intent. Model Penal Code, purposely, knowingly, recklessly, and negligently. Your default under the Model Penal Code, recklessly. They probably aren't going to ask you about that, but in case they do, there it is. Okay, parties to a crime. Again, making a distinction between common law and MPC, because you probably just learned MPC. They love to test the common law. So your parties to a crime at common law. 4. You got your principal in the first degree, principal in the second degree. Principal in the first degree is the one who pulls the trigger. Principal in the second degree, somebody who aids and abets at or during the crime. Accessory before the fact, that's the person who helps you before you get to the crime. Accessory after the fact, someone who helps you escape or covers up the crime. At common law, all 4 parties could be guilty of the substantive crime. Some erosion of that under the modern trend, if you will, but they're going to test you on that basic common law rule. Under the Model Penal Code, you have the principal, the accomplice, and then somebody who's guilty of obstruction of justice. The principal is the one, again, who pulls the trigger. The accomplice, that's the person who aids and abets before or during the crime under MPC. Obstruction of justice, you help to conceal afterwards. Big difference under the Model Penal Code, obstruction of justice is not going to carry the same penalty as the substantive crime. It's a lesser crime.
What did you say about? I'm sorry. What did you say about accomplice?
Accomplice, that's somebody who aids and abets before or during the crime. Okay, inchoate crimes. Solicitation, attempt, conspiracy. Solicitation, all you got to do, remember, always, of course, at common law, specific intent crimes, Model Penal Code, you're going to need purpose. Solicitation, all you have to do is ask, right? You make the ask, you're done. The crime is committed. Attempt, you have to take some kind of step, and it's called different things, and exactly how far you have to go depends on the jurisdiction. Model Penal Code, it's just a substantial step, right? The key, though, with attempt is you cross the line from preparation to perpetration. And then conspiracy, of course, important. These two, solicitation and attempt, merge into the completed crime. Conspiracy does not merge, except one exception under the Model Penal Code I wouldn't worry about. But for the most part, conspiracy does not merge into the completed crime. So what do you need for conspiracy? You need 2 intents. You have to intend to make the agreement, and you have to intend to achieve the object of the agreement, the criminal object. So you got to intend 2 places when it comes to conspiracy. And of course, again, you have to have that act. At common law, you didn't need any kind of extra step. Today, common law and Model Penal Code, except for certain kinds of crimes, you need some kind of act, but mere preparation would be enough. Question?
The Wharton rule is only Model Penal Code?
No, other way around. Wharton rule is common law. Wharton's rule deals with situations in which you already have 2 guilty minds. Remember, for conspiracy, the idea with conspiracy and the reason why it does not merge into the completed crime is that you've got that extra added agreement and the extra guilty mind. Common law says that a conspiracy is an agreement between 2 or more persons. Model Penal Code says an agreement by a person. So there are two issues to consider there. One is is Wharton's rule, and the other is your typical fact situation with an undercover cop. Let's look at Wharton's first, and then we'll look at the undercover cop. Wharton's rule says that if your crime already requires 2 guilty minds, then you need another guilty mind to make a conspiracy, or else there's no difference between the crime and the conspiracy. And so they should merge. So what kinds of crimes do you look for under the common law? Bigamy, incest, dueling, maybe receiving stolen property. So dueling is an easy example. If 2 people are going to go out and duel at dawn, you've got 2 guilty minds. To have a conspiracy to duel, you have to have somebody else come along with them, if you will. But you need just 1 guilty mind under the Model Penal Code, so you don't need Wharton's rule. Wharton's rule, again, common law, when you need that extra guilty mind. Now, that second issue, the very typical fact pattern in multiple choice. When somebody walks into a bar, sits down, starts chatting up the person sitting next to him, and they cook up a plot to go rob a bank. If the person sitting next to the one who walked in is an undercover cop, under the common law, you don't have a conspiracy. Under the Model Penal Code, you can still have a conspiracy because you need just 1 guilty mind. Question?
Are you liable for prior acts of conspirators? You joining this conspiracy and they've already done some crimes?
That's a complicated question.
You said after the fact.
No, that's different. That's an accomplice liability. That's a different issue. Well, Pinkerton's different too. Yeah. The question was, if you join a conspiracy at a late point, are you guilty of crimes that were committed before? It in large part depends on whether you have 1 conspiracy or multiple conspiracies. My criminal law class just cooked up some great conspiracies, and we had a discussion about one in which a hitman was hired at the end to kill everybody else in the conspiracy. Probably he doesn't have liability for what went before. I'm not going to say they can't, that they won't test it, but that gets into really complicated questions of fact. And the Pinkerton issue, and Pinkerton's complicated too. Pinkerton isn't followed by a lot of jurisdictions, but under Pinkerton, you're liable for anything that's done in furtherance and as a result of the conspiracy, even if you didn't do the act and even if you didn't know it was going to happen. It's a pretty broad rule, which is followed at least by some federal courts. So the Model Penal Code has rejected it, but some federal courts do follow it. Okay, just going to, crimes of the person, most of these, I'm not going to worry about. Homicide's the one that I will take a few moments on. Under the common law, and here they're going to test you common law. Unless they give you a statute, sometimes they do. They give you a statute, just apply the statute. But they're mostly going to test common law. You've got the first-degree murder that's premeditated and deliberated. So you have to have some moment to reflect, even if it's a very small millisecond, enough to reflect on what's happening. Common law murder, though, is your typical murder, the malice crime, the unlawful killing of another human being with malice aforethought. 4 kinds of malice. First kind is express malice, which is intent to kill. 3 kinds of implied malice. Intent to inflict serious bodily injury, depraved heart, which is reckless disregard for the value of human life, and the third, felony murder. Now, do watch out for felony murder. It is, at least abstractly, it's second-degree murder, because common law murder tends to be second-degree murder. But if they give you a statute, they can put felony murder as first-degree murder. They can put it as third-degree murder. Follow the statute. Voluntary manslaughter is mitigation. The only way you get to voluntary manslaughter is by having some kind of murder that is mitigated. mitigated usually through heat of passion. With heat of, question?
Is voluntary intoxication mitigated murder to manslaughter?
No. Good question, though. The reason that the malice crimes were carved out in the first place is to deny certain defenses to those malice crimes because they were particularly heinous crimes. One of those defenses is voluntary intoxication. So voluntary intoxication is not a defense to common law murder. And it's not a mitigation factor. The other is unreasonable mistake of fact, because for your specific intent crimes, unreasonable mistake of fact is a defense, but it's not to murder. But can you get from murder to manslaughter through something other than heat of passion? Imperfect self-defense is the other mitigation there.
Did you say that unreasonable mistake of fact is not a defense to first-degree murder?
No, it is.
It is. Okay.
Right. Unreasonable mistake of fact is a defense to any specific intent crime. But it's not a defense to a malice crime or a general intent crime. And involuntary manslaughter is going to be criminal negligence or misdemeanor manslaughter. Yes, sir?
Sorry, with imperfect self-defense, that's responding with deadly force to non-deadly force?
Imperfect self-defense is going to arise typically when your belief in the need for that deadly force is not reasonable. Now, crimes to property. Make sure that you know the elements, particularly when we're talking about, I don't know if I have them all there. Oh, because there's embezzlement. You want to know the elements. What's larceny? What's false pretenses, robbery, embezzlement, etc. Know your elements, because that's what they'll test there. And the thing that you're likely to struggle with, difference between larceny and false pretenses. Now, I'm going to give you an example from a case that I think is the best illustration of the difference between larceny and false pretenses. And you're very likely to see that distinction on the exam. So the example that was given in this case is a guy drives into a self-serve gas station. And the clerk can see, as is always the case, the clerk can see the people at the pump. The guy pumps gas and then just drives away. Example number one. Now, the clerk sees the guy pumping gas and he just drives away. You want to view the distinction, larceny by trick and false pretenses, from the perspective of the clerk or the owner of the store who's being represented by the clerk. What does he intend to give away? When you pump gas, I pumped gas into my car this morning. I should get possession to start with, right? Because I put the gas into my gas tank. If all I get is possession, it's larceny. And if I pump the gas in and I drive away without paying for it, surely the store owner is intending to give me no more than possession. Larceny by trick, because I pull in, it looks like I'm going to pay, and then I drive away. Contrast that to the guy who pumps the gas, walks in, and pays with a counterfeit bill, which the clerk cannot tell is a counterfeit bill. What did the owner intend to give at that point? Ownership or title, yeah. And so you have false pretenses. So the distinction between the two rests in the viewpoint of the owner. What's the owner trying to give?
Do you have a better example to that? Because in my eyes, when you're pumping gas, you're taking it. You're intending to take it with you. That's titled to the gas.
No. You're not from your perspective.
I understand.
It's the perspective of the owner of the store.
I think if someone's pumping gas in their car, they're going to take it with them?
No. What does the owner intend to give? That's the key, Josh. What does the owner intend to give? The owner, as soon as you start pumping gas into your car, the owner is giving you possession of the gas, right? But the owner's not giving you title until you pay for it. That's the key. And think about that, because that's the distinction. Question?
Sorry, you said the first example would have been larceny?
Larceny by trick. Larceny or larceny by trick, yes.
Both of them? Or
Oh, okay. The question is it larceny or larceny by trick? It's probably larceny by trick because you pull in and you look like you're going to pay, right? Larceny by trick and larceny are basically the same crime. It's just you use artifice with larceny by trick. And the reason the distinction is this. With larceny you need larceny by trick if it looks like the owner is voluntarily giving up possession. So if the owner sees you pumping, then the owner is voluntarily letting you have possession of the gas, right? So that's when larceny by trick becomes an issue. If you just take something from someone and he or she doesn't know, that's plain larceny because they didn't give you permission to take it. So that's really the distinction. Could you have plain old larceny, possibly if the owner's not around and nobody sees you? That's why the fact pattern could be one or the other. Does that answer your question?
Kind of, I guess. It's really tricky because usually they'll give you all three of those: larceny, larceny by trick, and false pretenses.
Yeah. Well, in that case, the example I just gave you, because somebody was watching, it's larceny by trick. So you have to look very carefully at the facts. It's larceny by trick if somebody's watching because they gave you permission to take the gas. If nobody's around, it might be just larceny. There's the difference.
There was a Kaplan question that's similar to that, but the person was going through a drive-through at a fast food station.
Okay.
He ordered the food, and the teller gave
Hand
him
it.
the food, and he drove off.
Okay.
And that answer was larceny. Couldn't there be an argument for larceny by trick? Because
Did they give you that option of larceny by trick? Yeah. It's larceny.
Okay, so on the test, if you see something like that, go larceny by trick.
Yeah. That particular example, if I'm understanding the question, now I haven't seen the question, it sure looks to me like it would be a knockoff of the case I just gave you, which would be larceny by trick. Again, focusing on what the owner was intending to give. We'll talk at the break, Josh, okay? Crimes 2. The habitat, just briefly, and we're going to take a break very soon because I know you're getting tired. Burglary. Use the common law elements of burglary. Breaking and entering of the dwelling house of another at nighttime with the intent to commit a felony therein. Model Penal Code doesn't require the breaking. Model Penal Code doesn't require the nighttime. Model Penal Code doesn't require a felony. Use the common law elements. Any kind of breaking is enough. If you move the window a little bit, if you push the door a little bit, there's a case in the case book I use. The court says if you stick your elbow in just a little bit, any kind of breaking is enough. Nighttime, it's in between dusk and dawn, basically. But technical definition has to do with what you can see with the naked eye. But they're not going to test that. So if you can see with, and it says, can you see without a candle? Because it's an old rule. So if you can see without a candle, it's daytime.
I know the common law uses a body part has to enter, but then there's a modern that uses, like, it says it can be a tool.
A tool. It can be a tool.
Which one?
On the exam, it's a good question. I would probably pick the tool because that particular case I mentioned because what they did there was they stuck a screwdriver around. They were stealing doors. Why? I don't know, but they were stealing doors off houses, and they stuck a screwdriver around. So yeah.
Breaking?
Yeah.
So I think they said, if it's an open door or window, that doesn't.
It's not breaking. You got to. That's why I said you have to push a little bit or raise it a little bit, some little bit of something. If it's an open door and open window, it's not breaking. So you might be entering, but you're not breaking. It's not burglary. Then it could be larceny if you're taking something. Absolutely. Arson. The only thing I want to mention about arson is, remember, at common law, arson is a malice crime.
the crime you commit, once one breaks in, commits a burglary, does that merge with that burglary?
Oh, it could. It could.
So, but, because I've seen sometimes where answers are
Oh,
burglary and larceny or burglary and something else.
It's a really complicated question, Frank, that we can talk about on the break. But I don't want to brush it off, but it's complicated. Okay. Okay, briefly on defenses, I did get, of course, the question about insanity. I'll pull up a slide when we come back so you can take a look at the difference between the four. Defense of person, defense of others, defense of property. Those rules are pretty straightforward, so I'm not going to spend time on them. Mistake, remember, today mistake is generally going to be something that negates the mens rea. Years ago, I would teach it as a true affirmative defense. Again, today, you're going to look at mistake in the context of mens rea. As I said before, if it is a mistake, reasonable or unreasonable, it's going to negate specific intent. It must be reasonable to negate malice or general intent. Impossibility is almost impossible to use, right? It's probably the easiest way to remember it. The only time that you even think about impossibility is in the context of attempt. Impossibility is not a defense to anything else in the world. It may, under limited circumstances, be a defense to attempt. But it's got to be mistake of law, not mistake of fact. You stick your hand into the empty pocket to take the wallet that's not there. That's mistake of fact. So sad, too bad, you're guilty. Mistake that is a mistake of law. There's a lot of debate, and when you get your hybrid mistake cases, impossibility cases, the law tends to treat hybrid impossibility as not a defense. Hybrid impossibility, the easiest example is shooting a dead body. Once upon a time, shooting a dead body, you did have a defense of impossibility. Today, it's treated like factual impossibility, so you're still guilty of the attempt. I'm sorry? I'm sorry? What, your question?
I'm sorry. Did you give an example of an impossibility? Did I miss it?
Oh, no. I'll give you an example of legal impossibility that's kind of hybrid, but that's probably still a good defense, which deals with a check. To alter a check, which you should all know by now, you have to change the written words. If you take a check and suppose the check is for $10, and you add another 0 up on the line with the numbers, you're attempting to alter the check, but the legally significant portion is the written words. So if you don't change the written words, you haven't successfully altered the check. Case law has said that then that's legal impossibility, and you do have a defense to attempt. But that's mostly the exception and not the rule. And again, impossibility tends to be treated like factual impossibility in most cases. Shooting the dead body is a good example. So be very cautious about picking impossibility as a good defense, even to attempt. And as I say, I would look for the check alteration. That's your most likely example. Okay, I don't think I have the. Okay, let's do this. Let's take a break so I can pull up the insanity slide. Question? Oh yeah, I can do the raffle right now because I know some of you may want to be hitting the road. Yes.
Because I played it online, so I don't know if I still can put my name on it.
Find one someplace, Monica. You can. Okay.
Excuse me.
Okay, hang on 1 second, and I'll do the drawing. And let me ask you this. If you can do me this favor, evidence would be next. And I did have I had a question about character evidence, so I want to kind of address that. I had a question Oh, what else do I have there? I had questions, which I'll do at the end, kind of a game plan for commercial paper and/or secured trans. So I've got that. What else did I get asked about? Oh, taxation in Florida con law. That's in there. That may not be high on your list. It is hard. I want to get to some of those things, and if there are other subjects, do you want to even think about property, which I can give you kind of an overview on property, torts, but we are going to have limited time. Think about the Florida subjects that you might want to have a focus on, if at all, besides the ones I just mentioned, because we will run out of time, and I know that some of you are going to want to be hitting the road sooner rather than later. So as we take the break, just kind of let me know what you want covered. Okay, so final raffle of the season, which I am mixing up really good. All right. Kevin. Oh, no, Cudlip. Sorry, Dee. It's Cudlip. Sorry, Kevin. Okay. Now, let me just say a word as we take a break. For those of you who are going to hit the road now, I wish you guys the very best of luck on the exam. I know you guys have been working really hard all summer, and so we're going to see some great results from all of you. Good luck. If you have more questions, you can always email me in the next couple of days. But for the rest of you, when we come back, we'll pick up the conversation. Okay, folks, let's go ahead and go back to the materials. And I do have up that insanity slide that I promised. Just a couple of things to point out. With the test, your typical, you will have a question on the multiples on the MBE portion that's going to ask you to distinguish among these 4 tests. So you're going to start with monotone, which of course is the common law rule. It's the Florida rule, and what you are looking for there is the defendant who can't distinguish between right and wrong, or understand the nature and quality of the acts. So the 2 things, again, doesn't understand the wrongfulness of the actions, can't distinguish between right and wrong, or doesn't understand the nature and quality of the acts. And I don't know why. Something's whited out there on Durham. That's just formatting. Under Durham, that's what that says there. Nobody follows Durham except New Hampshire, right? Just a product of a mental disease. So the chances of Durham being the right answer are relatively slim. Irresistible impulse, of course, is important in the way it ends up in the Model Penal Code, to be honest. Irresistible impulse, you can't control your actions or conform your conduct to the law. The key is you can't control your actions. We get to the Model Penal Code, it's a combination of monotone and irresistible impulse. Okay. Now, I got different requests in terms of what I do next. So I'm going to be very democratic. Because I want to know from you guys as a whole, and I can't please everybody at the same time. I realize that. We have 2 options. The next naturally in line is evidence. I did get a request to bump the commercial law and the secured transactions up a little bit. Up to you guys. How many want to just keep going with evidence? Okay. How many want to do the commercial law? And more want to do that. That won't take all that long for those of you who want to do evidence, because I'm not reviewing the whole subject. Can't do it. But what I did do, you have in your packet, kind of little game plans, if you will, if I can find it. When it comes to commercial paper, the chances are good that you'll get some kind of holder in due course essay, if you get one. Or it's part of a property or a contracts question, or possibly even a torts question.
How could that be? What in torts could that combine?
The question is where in torts. You'll see when we get to defenses that there are negligence-based defenses. So that's how the two could be combined. You've got negligence, just basic negligence, and then you've got the fictitious employee, and you've also got conversion, which is a tort. So that's really the combination. It's less likely, probably, than the other, but it is still a possibility. All right, so if you get an essay or a component of an essay, and especially based on essays they've given in other states on this topic, you'll probably be looking at those components, some or all of the issues that I have listed there. So we start with the negotiable instrument. Now, if you came to Professor Martin's lecture, you know how important it is to know your elements. And honestly, when I used to teach with commercial law, which is a while ago, I taught them in sliced a little bit differently, but I've listed them here as Professor Martin lists them because that's what you've already seen. And it doesn't matter as long as you get the components down, whether you say there are 5 parts or 7 parts, which I think she told you. So you've got to have that written promise or order. It's got to be an unconditional obligation, right? Fixed sum of money, which is important, and it's got to be for money. Payable to bearer or order, very important, not just paid to a person, but bearer or order. It's got to be payable on demand or a definite time, and no additional undertakings, meaning that it's not tied to some other, that's the courier without luggage, but the idea is it's not tied to any other transaction.
Yeah, I was confused on that when they said you can't have an additional undertaking, but then there were exceptions to that, and one of them was you can restrict where like a payment would be from.
Right.
But my question is, the example they gave was, all right, like from the funds I received from the sale of my grain.
Mm-hmm.
What if that never comes to fruition? Then it's conditioned on you getting paid, isn't it?
Well, it's it is. Yeah, but it does. But that's not what you're saying, right? You're just saying I'm paying it from the funds that I get.
If I don't get those funds.
Yeah, but you're not expressly saying that it's conditioned. I think that's really the key. I'm trying to come up with an example that would show the distinction, and one is not popping into my head at the moment. Give me a few moments, and maybe something will scroll in there. Okay, your parties. At least get some vocabulary there. The people who sign the instrument. The person who signs on a note is the issuer of the note. The person who signs on a check is the drawer of the check. And don't forget about your endorser. Endorsers usually sign on the back, but quite frankly, they can sign any place. And they are signing for a variety of reasons. Could be an accommodation party, which probably you won't have to deal with. Sometimes transferor liability. I've seen it pop up in questions. I think it's less likely, to be honest. I have a little bit in here on transferor, but usually it's going to be the parties who actually sign on the document. The transferor who doesn't sign, though, could be the thief. And so you have to at least keep an eye out for that. Somebody who steals bearer paper and then negotiates it by simply transferring it, never signed, and yet could have transfer warranty liability. Drawer or acceptor, the drawee is I thought for a second I spelled that wrong. The drawee is the bank that's upon which the check is drawn. The acceptor could be the bank or it could be somebody who's accepting for payment. I wouldn't worry too much about them because you really kind of have to get into Article 4 stuff to make that a big issue, and They aren't testing Article 4. So your signers, that's going to be your primary focus, and maybe a thief who transfers. Question?
I do.
Yeah.
Of course. Okay, so when you're saying like the signing, are you talking about like endorsement liability?
Could be.
Or transfer liability? Or how are we supposed to do? Because like I didn't take commercial law,
Right.
so I have no clue.
If you sign on the check, you are liable in the capacity in which you signed, honestly. And that's the most important point. And really, at this point, again, I can't get into all of the details of commercial paper here. And I know many of you didn't take the course. But at this point, just look for the person in the capacity in which he or she signs. Okay? All right. Now, defenses to liability on the instrument. Here we're talking about the person who signed the instrument, as opposed to defenses that can be asserted against a holder in due course who takes the instrument later on. So make that distinction. So a person who signs the instrument, as I said, is going to be liable in the capacity in which he or she signs with certain defenses. The first, of course, is an unauthorized signature or an alteration. Because if somebody signed your name for you without your authorization, you have a defense with some exceptions. If you're negligent, and somebody signs your name because you're negligent, you may not be able to avoid liability. If your employee, for example, gets a rubber stamp of your signature, it's a typical situation. The employee gets the rubber stamp and stamps your signature on checks, you may have liability. Fictitious payee as well. Less likely, honestly, to come up in this case. It's more likely that there's going to be some kind of negligence, and very possibly involving your employee who gets the rubber stamp or sticks the checks under your nose under circumstances in which you should have known what you were signing. Question?
With relation to the conversion of an instrument, would you mention the criminal aspect at all, just theft?
Honestly, you could have a criminal cause of action, but the conversion that they're talking about here is common law, because conversion is not a crime, it's a tort. And it is the common law tort of conversion, so that's what you would do at that point. Somebody asked earlier, how does commercial paper combine with tort? There's an example. And you see, again, the negligence aspects. That's where tort would come into play in a commercial paper question. Now, negotiation, important, because if you have a negotiable instrument, and remember, we're assuming we're going to have some kind of holder in due course essay, which would be the likely type of essay, then the paper has to be negotiated. It has to be transferred to somebody else. How do you negotiate? If it's bearer paper, which means it's made payable to bearer in the first place, or there's a blank endorsement. Because if Jaquetta writes a check out to me, puts my name on it, and I sign my name and nothing more on the back, that's a blank endorsement. It's now bearer paper. And so if somebody steals the paper from me, it's bearer paper, and whoever has possession is the holder. So you transfer again, you negotiate is the term that you use for a negotiable instrument. If it's just bearer paper, transfer of possession. If it's order paper, which means it's still made payable to me, then you endorse and you transfer possession. Josh?
Is there any effect, or what is the effect, if any, by endorsing the bearer paper? Or is it
Not a good idea.
because then it creates liability, right?
Exactly right. So you don't want to endorse bearer paper. Exactly right. Because then you pick up liability you wouldn't have otherwise.
Unless you put without recourse.
Well, yeah, but why you're going to endorse without recourse when you don't need to endorse in the first place?
I was
Yeah.
bringing that up because for essay.
Yeah.
Just making sure.
Yeah. But it's a good point. But once again, the bottom line is you would not want to endorse bearer paper. Okay. Now, a person who takes by negotiation, and maybe I should have put that little step in there, but if you take by negotiation, you are now a holder of the paper. The question is, are you a holder in due course? Do you enjoy the special privileges, if you will, of a holder in due course? To be a holder in due course, you have to take in good faith. You have to take for value. You, of course, have to take innocently and without notice of unusual circumstances, anything that should have put you on notice that something was wrong with the instrument. And if you are a holder in due course, as I say, you get special status. You're going to take free of personal defenses. However, even a holder in due course takes subject to real defenses. So what are your real defenses? Infancy, duress, fraud in the execution, bankruptcy. The rest, your statutory defenses like payment of the instrument, defense based on the underlying obligation itself, or personal fraud, those you will take free of.
Defenses like fraud in the execution and duress, infancy, is that contract defenses?
Yep, they are contract defenses, yes. Now, transfer warranties, because if you transfer an instrument, and if you need to endorse, which goes back to Chiquetta's question, then you may have transfer warranty liability, and you're going to warrant a number of things. You warrant that you're entitled to enforce, which once again is why you don't want to endorse if you don't need to, right? All signatures are authentic. Instrument hasn't been altered. It's not subject to any claim or defense. And you don't know about any insolvency proceedings. Yes, sir?
So unless you're a thief, this is the only time that a transferor would be held liable for breaking one of these.
Right.
Because
Now,
otherwise there's no basis.
That's right. And of course, a thief is got the criminal liability. Going back to somebody else's question, you may have criminal or tort liability for being the one who stole the instrument. Now, are there other issues? Obviously, there are, and you know, I can't predict. But as I've looked at the types of essays that have been given in other states, and thinking about the types of topics they're likely to test, if you kind of follow this formula, chances are good, if you get a commercial paper essay, that you'll have something intelligent to write, which is always a good thing, right? Chiquetta, you have a question?
Yes, ma'am. Okay, so when you presentment, when the person is demanding payment,
right?
What is it? The maker? No, not the maker. The bank is the
drawee.
The drawee.
Well, the drawee is the one who actually has to pay, right? The drawee bank.
Okay, so it could be either a bank doing presentment, or it's the person who received the.
That's correct, because
the last person to transfer title.
That's right. If, for example, the check that you wrote payable to me, what's your bank?
Wells Fargo.
Okay, Wells Fargo. I bank at Wells Fargo too. So I go to Wells Fargo. It's the drawee bank. But suppose that I bank at Chase. Thank you. And I go to Chase. Then Chase would then present.
And then they not only are they going to say like they have presentment warranties, but also
transfer warranties. You got it. Okay. Yeah, and I didn't even put the presentment warranties up because I have to tell you, I think it's not so likely that drawee liability is going to become an issue in the essay. Because once again, you really need to get into Article 4 to make that picture work well, and Article 4 is off the table. But your description is correct. Okay.
Okay. They were saying like if there's some forgeries that don't break. Like if I forge a note, or that it breaks, everybody behind me can't be a holder. You know what I'm saying? Like every successor after that, forgery can't be a holder. No.
Well, I need more from your example, but we can talk a little bit later. Yeah.
Okay.
Okay. Okay. Other questions? Yes.
If you, okay, this is like a dumb question, but if
Okay.
you endorse a check, right? Does that make it from order paper to bearer paper?
It depends on how you endorse.
Okay, so how do you have to endorse?
If you endorse in blank, if you just sign your name on the back, it becomes bearer paper. If, which you really can't do these days, suppose I endorse the check over to you, make payable to, that's not a blank, that's a special endorsement. It's not bearer paper. Or if you do what I do and what Professor Martin told you all to do, I put on the back, I put deposit, and I put my account number, for deposit only, account number, dot, 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 and then I sign my name. That's not a special endorsement again, so it's not bearer paper.
If you get it combined with property,
Uh-huh.
the only way that it could combine is basically if you have mortgage note situation.
Yes.
And the note is transferable.
Yes.
From one house.
Yeah. The question is, and it's but you're absolutely correct. If commercial paper is going to be combined with property, it's likely to be a mortgage. Absolutely. Because remember, a mortgage includes a note. And we've just been talking about checks. But a negotiable instrument can be either a note or a check. It can be some other things, but for your testing purposes, it's going to be a note or a check. So absolutely, it could be a mortgage situation, no question. All right, now let me take just a few minutes and give you kind of a structure, and nothing much more than that, on secured trans. A little harder. A little harder for me, honestly, to structure here because I have taught commercial paper, but I haven't taught secured transactions. So when I look at commercial paper, a lot of cases come into my mind, and I can see where they're going. Not as easy, honestly, for me with secured trans. Nevertheless, I have a feeling, as I review the materials, that these are the areas that they would be likely to test. First, you have to create that security interest, right? And then you have to perfect it. The subject matter isn't logical, but once you get the feel for the subject matter, this order is logical. Then you're going to have some competing interests. You've got to resolve the priorities. And what kinds of remedies is the creditor entitled to if the debtor defaults? And then maybe possibly an issue of the right of redemption. But quite frankly, most of the issues are going to be in perfection and in priorities. So let's take a look again. What do you need to create a security interest? You have to give value. You have to have some collateral that the security interest is in. And then you have to have that security interest document, right? How do you perfect your security interest? Here, the only thing you can do here, if you are not familiar with the area, is just do some memorization as best you can. Because there are a lot of different methods of perfecting. The easiest, of course, is to file the financing statement. But you can also have perfection by possession of the collateral if you've got something tangible. You can have perfection through control if you've got accounts, for example, investment accounts, deposit accounts, if you've got control. There's also automatic perfection for that purchase money security interest, which honestly is something that if they want to test, that's a good area, I think, for them to test. And what is that purchase money security interest? Money's lent to the debt. I'm having trouble talking. To the debtor to buy the collateral. And you have seller financing. Kevin?
I was a little confused on that. If you have a purchase money security interest that automatically perfects in consumer goods, but you also have another debtor or creditor?
We're going to get there.
Okay.
Yeah. We'll get there in a moment. So first, but remember first, what you have to do before you get to the question that Kevin is raising, you got to perfect first, and then you're going to deal with your priorities. So don't jump too fast to priorities. Kind of go in order, which is again why I've spelled it out this way. The more that you follow the order, the easier it is going to be for you to deal with a difficult subject. So also remember you have temporary perfection for 20 days. So establish some method of perfecting the security interest. Now, if you've got competing claims, then you need to know, are they perfected? Are they not perfected? If you have two unperfected claims, then your old common law first in time, first in right rule is going to apply. Very simple. If one party's perfected and the other is unperfected, then obviously the perfected interest is going to prevail. If you've got two perfected interests, then you go back to first in time, first in right. Special rules for purchase money security interest in inventory. If you've got that purchase money security interest in inventory, it's going to prevail if it's perfected when the debtor gets possession of the inventory and notice is given to prior creditors. So you got to add in that notice to prevail when it comes to the purchase money security interest. If it's equipment, then the purchase money security interest in the equipment wins if it's perfected before or within 20 days after the debtor gets possession of the equipment. And look at the difference between inventory and equipment, and I've seen them test the difference in essays in other states. So inventory, that's what you're selling, right? Equipment may be what you use to sell or to do whatever, to manufacture or whatever. Make a distinction.
That notice, that's not like they don't go out and look for everybody that
No.
they just, that's a financial statement, whatever.
Right.
Yes.
That's sufficient notice.
That's what they find.
Yeah, that's sufficient notice. Right.
The PMSI and inventory doesn't have the, within 20 days of delivery.
No, I don't think so. No. Not to the best of my knowledge, anyway. Okay, so if you've got conflicting purchase money security interests, if it's based on seller financing, the seller wins. Otherwise, first to file and perfect wins.
What do you mean? What's that mean?
What I'm
Based
saying.
on the seller's financing, the seller wins.
Oh, seller financing is when the seller is the one who actually gives the financing back, as opposed to some other, like a bank financing.
So, well, okay. So you have a party who wants to get collateral in their own inventory, so they give a security interest to the other party. So who's the seller in that situation? What do you mean seller? Like, are you talking about the party giving the collateral?
No, no, no. The party who's actually selling the item that has already been the subject of. So you want to acquire inventory to sell to somebody else. You get the purchase money security interest to get the financing to buy the inventory, and then you sell it to somebody else. So suppose you have a shoe store. You got to stock it with shoes. You got to borrow money to get the shoes, okay? And so you borrow money from somebody and is secured with purchase money security interest for the shoes that are now your inventory, right? Okay, and now you're going to sell the shoes to somebody else. Yeah?
No, it's fine.
Okay. Okay. Again, these are difficult areas, and we could spend a lot of time on them, which probably isn't the best use of our time.
Can you talk about the difference between a purchase money security interest and like a mortgage? Like, is there like
Purchase money security interest is going to be for goods. Mortgage is going to be for real property. Really, that's the.
mortgage goods?
It's not a mortgage in the traditional sense. Can you use goods as a security interest? Absolutely, but it's likely going to come under Article 9 and not the common law rules for mortgages that you learn in your property class. Okay. Now, kind of going back to the question at least the example I was trying to use with Jaquetta. Because if you buy the item that's subject to the purchase money security interest, okay, do you take free of the interest? If you buy the item, you give value, and you take notice without the security, without knowledge of the security interest, if you take before it's perfected, then you're going to prevail. So you're a regular buyer. Now, there's that special category for a buyer in the ordinary course of business, because you buy in the ordinary course of business if the seller's engaged in selling goods of the kind, which is Jaquetta with her shoe store. And if you buy at the shoe store, you're going to take free and clear of the security interest unless you know about security interest, which isn't going to usually happen. If I walk into her shoe store to buy shoes, I'm a buyer in the ordinary course of business because that's her inventory. Chances are slim that I'm going to know how she paid for her inventory, right?
Those two things are basically the same. Right?
Well, your regular buyer isn't somebody in the ordinary course of business. So if it's a one-off sale, right? If suppose that Jaquetta, I'm sure we don't have the same size feet, but Jaquetta buys a pair of shoes, and I say, wow, those are really cool shoes. Can I buy them from you? That's your regular buyer, okay?
But I mean, they're both protected.
They are both protected. The rules are just a little bit different.
The distinction is who it is, but
Yeah.
they both get the same protection.
Pretty close,
No
yes.
one's going to take your shoes.
Yeah, nobody's going to take my shoes unless I know about it. Yeah.
I thought if you're a regular buyer, if it's perfected, they can come after you.
Well, yeah, you're right. That is the distinction. Because remember, for a regular buyer, you have to take before the perfection occurs. So absolutely correct. Up, right, someplace up there. Before perfection, yeah. But here, even if it's perfected, if it's in the ordinary course of business, you take unless you know. That's the distinction. Okay. Let's look at creditor rights in the event of debtor default. What can the creditor get if the debtor doesn't pay? The creditor can repossess the goods, right? The creditor can sell the goods. And that's what they're likely to test, because if the seller sells the goods, going back to the question about mortgages, now we start to see something that is very much like mortgages. Because if the creditor sells the goods, you distribute the proceeds in the following order, which is very similar to how proceeds are distributed for a mortgage. First thing, expenses of a sale. Then the debt that's secured. And then your junior lien holders. If there's anything left over, the debtor gets it. If there isn't enough to go around, deficiency judgment, assuming your jurisdiction permits a deficiency judgment, which Florida does. And then finally, you might have an issue of redemption, and again, it is a little bit like mortgages because you do have a right to redeem before that sale of the item. So as long as you pay up and pay off, if you will, you got to pay the full amount before the item is otherwise disposed of, you can get it back.
Is there any statutory right of redemption after the fact?
Not in Florida. You do have a statutory right of redemption in other states, but not here.
We don't even have that property in Florida?
We do not. We do not. Statutory right of redemption? No. We have equitable right of redemption in Florida, absolutely, but we do not have a statutory right. Oh, just, okay. Okay, other basic questions. All right, then let's, unless there, yes, sir.
Not really basic questions, but like to the call of the question, what are we looking for? What are just
the call of the question in secured transactions is likely going to be who prevails. You know, I hate to say it, but they're going to give you multiple parties, all claiming an interest in one item, which is likely to be some kind of personal property. Doesn't have to be. Excuse me, but it's likely to be some kind of personal property. And so the question is going to be who prevails, who wins. Is it going to be creditor number one, creditor number two, debtor, you know, or purchaser, buyer who buys in the ordinary course of business? And your job will be then to determine whether, or determine who wins, really. That's your most likely scenario with secured trans.
Do you think commercial paper or secured transactions?
More likely commercial paper. Secured trans was tested last July, and it was part of a contracts question. Not surprisingly. I think they'll probably do commercial paper. Now, someone else asked, what else do I think is going to be tested? Okay, we can go back to that for a second, and then we'll pick up whatever other items you want to pick up. Okay. What should you be prepared for? Everything, right?
How often are you right when you?
I'm very right. Yeah, no. I have a particular. I got all 3 questions last time. The only thing I was wrong on, and I got to fess up, I thought the family law question would have some delinquency, and it didn't. But otherwise, I was right on. Because I thought torts, and I thought property, and I thought, family law, and I thought con law, and they were all 3 there. Now, not torts, property. It was, and I thought property would be easements and all that stuff that they did test. So even topic-wise, I was right on with property. So what do I think this time? Well, torts. Because I think everybody thinks torts is due. Some kind of torts. Somebody asked me in an email about the med mal caps. I have to tell you, and I thought about that a lot with the case that the Supreme Court said that the med mal caps in the context of wrongful death for non-economic damages, they found that to be unconstitutional. I don't think they can give you a med mal question this time. I really don't. They usually have several questions in the pipeline. And they can pull one back if they need to. And honestly, if I were them, can they test med mal on this exam? Yes, they can. But there's another case that's working its way through the Supreme Court right now. I don't think it's a fair question. So I'm kind of hoping, for everybody's sake, that if they have a med mal in the first place in line, if you will, that they're going to pull it. But does that mean they're not going to do torts? Probably not. No, they've got products liability. You got premises liability. You've got other kinds of negligence that doesn't involve medical malpractice. So there's a lot that they can do in torts. The least likely would probably be dignitary torts because they did test that fairly recently, and they don't do it a lot. Dignitary torts, defamation, privacy.
Oh, okay.
Sorry. Defamation and privacy, they're called dignitary torts, okay? Okay? They're freaking out, I know. Okay, so what else do I think? What else do I think is going to be tested? Well, the commercial paper, yeah, I kind of think that's going to get stuck in there someplace. Because they have to test something new this time. Delinquency, but for the fact that they had that big, juicy family law question last time, I would say family law and delinquency this time. You know, never say never. They could test family law again and throw some delinquency in. Although, yeah, I don't know. It's not top on my list. But commercial paper combined with contracts or possibly property, yeah. Contracts and property have both been tested a lot lately, but they combine so well with other things. So remember, they can have up to 3 subjects per essay. So combinations, you should be looking for combinations of topics. Florida con law, some aspect of Florida con law, I think is highly possible. Maybe even just homestead mixed in with property and some other stuff. And we talked about homestead last week on Friday, so make sure if you get a homestead question that you separate out those 4 different kinds of homestead issues that we talked about. So other than homestead, in Florida con law, they tend to test the following, some of which we talked about last week again. Bonds, yes, and I think bonds is a possibility. It's been tested, not so far in the past, but far enough back that they might test bonds again. So bonds, homestead, also what I call how a bill becomes a law, which is what they tested last time. So it's less likely, which is your single subject, access to court, separation of powers, contracts clause, all that stuff they throw in together. But I don't think that one is as likely this time. Also taking, they do like to throw taking in from time to time. We talked about that last week as well. So those would be the main topics. Again, as I said, somebody asked about taxation. There is a little cheat sheet, if you will, in the material we handed out today. If we don't get to that by the end of class, kind of things to think about again in the area of taxation, who can tax and what they can tax, and any limitations on the taxing power. So that's likely in con law. Trusts, I think, not as likely. Dependency, it's, you know, the question was asked earlier, how much do you need to know about dependency? I don't know. I wish I did. I really wish I did. Nobody knows. That's the wild card. Dependency. Could it show up? Sure. You're going to get dependency or commercial paper, one or the other.
That's what I was going to ask. What are the chances of them testing 2 new subjects?
They could, probably won't, but they could.
So you would say commercial or dependency?
Probably, yeah. And dependency can either be tacked down on an essay, or it could possibly show up in some multiple choice. Yeah, I don't know.
Question about this.
Yeah.
If it does come up in multiple choice, one of the lecturers said it's going to be one of the test questions. Right?
Good point. They could throw some dependency in as test questions, and the test questions are the ones they throw out. Remember, you get 100 multiple choice questions, but only 90 count. So it's true, your dependency. And by the way, you all are going to see civil procedure test questions on the MBE, so don't freak out. They were there last time. Just a heads up on that. You will. I'm sorry?
Just keep them.
Yeah. The question is, should you just skip them? No. Bubble in B or whatever they tell you to bubble in, you know? Yeah. If you don't know, just bubble something in. But remember that you will see some civil procedure questions. They're testing them out. They are there. They've already been there. And so just don't. They do not count. That's why I say don't freak out. Not this time. Next time they will. You don't know. Well, you don't know for sure. That's why you got to answer every question. But the ones that ask you things like, you know, the standard for summary judgment, or, you know, 12v6 or whatever, okay, that's pretty clearly a civil procedure question, right? Or joinder of parties, or you know your typical civil procedure stuff.
Test questions in the MBE thing also?
Good question. On the MBE, approximately 10 questions. Approximately.
And then in Florida?
Florida's 10 for sure. 10 for sure. Yeah. Now, when I say for sure, I can say for sure in Florida you get 100 multiple choice questions and 90 are scored. So it's approximately 10 that are experimental, if you will, maybe a couple that they throw out because they're bad questions, but approximately 10.
And then the curve generally adds like another 10 points to your life.
For the MBE, you have to talk about MBE versus Florida when it comes to scaling, because it's very different. On the MBE portion of the exam, they will scale somewhere between 10 and 20 points, usually. And it depends on how high your raw score is. Because if you get a 175 raw, you might get 4 more points scaled because you got most of the questions right? If you get a 117 raw, then you're going to get more scaled points because you got more wrong to begin with. So somewhere between 10 to 20 points scaled on the MBE. Florida is completely different because you start out with 390 points total in Florida, which they then have to scale back to 200 points. So you will get a raw score in Florida that is much larger than your scaled score. And You two could get the same raw score in Florida, but get a different scaled score in Florida because essay versus multiple choice. So just be aware of that as well.
But, okay, but the multiple choice part of Florida doesn't scale that much because it's fixed. So really the scaling is in the essays. So you have more wiggle
Well,
room.
it's not scaling, it's just the scoring in the essays. So you have a lot more wiggle room in the essays. That's why everyone will tell you it wouldn't matter whether you went to school in Florida or you went to school in another state. For the Florida bar exam, people pass or fail the Florida portion based on the essays. Everybody says the same thing. And again, it doesn't matter who you are, where you went to school, you pass or fail based on your essays. You have to write 3 good essays. Now, can you fail the Florida portion if you get 2 right on the civil and criminal procedure? 2 right out of 30? Sure, you can fail. But most people get the big point differential on the essays. Got to write good essays. Okay, and the multiple choice, you have to be tested on civil and criminal procedure. It's the only absolute on the Florida exam. Interestingly, the rules don't actually require civil and criminal procedure to be tested in multiple choice form. But it's never been tested any other way. So I really don't think you're going to get an essay on Civ Pro. Good news. Then you have 2 other multiple choice components, likely 2 other multiple choice components, never say never, of course, which have been drawn for many years from 3 subjects. Could change. Juvenile delinquency could be the game changer. But in the past, the 3 subjects from which they've drawn 2, business associations, evidence, Florida evidence, and wills administration. So it's likely you'll get 2 of those, probably Florida evidence, and I think more likely wills administration. But be prepared for business as well. Okay, any other general questions on that stuff? All right. At this point, do we want me to go back into evidence? Yes. All right, evidence. Let's get evidence up.
Are you going to go strictly over MBE evidence, or you're going to go over some of the distinctions?
I'll mention some of the distinctions as I go along. Okay, now for evidence, folks, and it's, I want to urge you to kind of go in order as you answer evidence questions, because it makes it a whole lot easier. If you start with the rules, some of you may do great with the rules of evidence, but a lot of you probably struggle with them. Lead yourself to the right rule. So you're going to do a 3-step process. What kind of evidence is it? Is it real? Is it demonstrative, etc.? And then the key is, what's it being offered for? And you pick that apart as much as possible. And when it comes to that awful behemoth called character, it's really not a behemoth. Because character evidence, it's a type of evidence, but what's it being offered for? If you break it apart, all of a sudden it's not so bad. When we talk about what the evidence is being offered for, we look at a lot of things. First, is it a criminal proceeding? Or is it a civil proceeding? And with character evidence, you know that in civil proceedings, it's I'm not going to say inadmissible, because it is admissible in certain limited situations, but less admissible in civil versus criminal. Who is offering the evidence? Is it, if it's criminal, prosecution or defense? If it's civil, plaintiff or defendant? And is it being offered on direct or cross-examination? And really importantly, for a lot of the multiple choice questions, what's it being offered to do? Is it being offered for the truth of the matter asserted? Probably not. Most questions, it's not. Is it being offered to do something else? Is it being offered to prove an element of the cause of action? Ooh, character. Guess what? Defamation. It's relevant. Is it being offered to show ownership or control of an item? Is it being offered to impeach? Think of everything other than the truth of the matter asserted. because that's likely going to be the right answer. And once you've gone through those steps, then the admissibility is a whole lot easier to figure out because you've led yourself to the right point. Is it admissible? It's not admissible. If it's that character evidence we were talking about, and the cause of action is defamation, injury to reputation is an element of the cause of action for defamation. Is that character evidence admissible? You bet. So lead yourself to the right answer. So let's take a look now, briefly, at types of evidence. Much of this I don't think we need to spend a lot of time on. Don't forget about relevancy. They do have a component of relevancy in the MBE, so you do need to know basic ideas of relevancy. It's more probative than not. It's got to help prove something that's an issue in the case. Scientific and technical evidence, the most important thing there, of course, is to remember that we now have Daubert in Florida. So we follow Daubert. Federal rules follow Daubert. Don't use Fry in Florida anymore. Someone asked me, I think, last week or a couple of weeks ago, should you even need to know Fry? It could come up on the MBE. They could still test it, but probably not. So focus in on Daubert. Opinion evidence. Opinion, maybe it should say / reputation. Opinion evidence is highly suspect in Florida, but it can be, as we discussed a couple of, I don't know if it was last week or the week before, it can be used in limited situations in Florida, which we'll talk about as we go through. What do you use it for usually? Impeachment, right? And same thing, of course, with reputation. Judicial notice, we just did know the difference, of course, under the federal rules. You're talking about manifest and notorious facts. In Florida, we recognize those two categories, but judicial notice goes way beyond fact in Florida and encompasses the various layers of law. Privileges. Really important. We spent some time when we did the evidence questions talking about privileges. Make sure that you review your privileges. Know, of course, that in Florida, there are a couple of noticeable omissions in terms of privileges. Because, number one, we do not have spousal immunity in Florida. There are two privileges associated with the marriage. One is marital communications. The other is spousal immunity, both recognized under the federal rules. But in Florida, marital communications only. So that's number one. And number two, of course, in Florida, we have no patient-physician privilege in the long list of privileges that we do recognize in Florida. Patient-physician is a much maligned privilege even under the federal rules, but we don't even have it in Florida. Question?
Is it possible that even though you're speaking to a physician, if you're speaking to him in the capacity as a psychotherapist, then that would...
Oh, if the physician qualifies as a psychotherapist, then you can be in the psychotherapist patient privilege. Also, you could possibly, remember, if you are referred to a physician by your attorney, then the conversation may be protected by the attorney-client privilege. Yeah, don't forget about that. Which is the way that you usually get the information protected under the federal rules as well. Remember, of course, that even under the federal rules, which again do recognize patient-physician, I'm getting tired, patient-physician privilege, hard to say when you're talking fast, you waive the privilege if you put your condition in, or in issue, right? Okay, types of evidence, not much to say here, real, documentary, testimonial. If I take the Zephyr Hills water bottle and I whack Rosario over the head with it and kill her, it's real evidence, right? But if we have a products liability case, and the question is, what are the contents of that bottle? What's written on it? Becomes documentary evidence, right? And of course, then, much of what you're going to be dealing with on both parts of the exam will be testimonial evidence. Daubert, we talked about opinion. Lay opinion versus expert opinion. Remember, with lay opinion is possible for anything that is within the general normal understanding of a lay person. Wow, that car's going fast. Or, yeah, he kind of looks drunk to me. Not that car is going 75 miles an hour, or he had a blood alcohol level of 0.08 or whatever. And remember, in Florida, we don't like lay opinion, but it's not that you can never have lay opinion. Remember that the statute says that a lay person cannot testify in the form of opinion unless there's no other way that the testimony can be elicited. Expert, always relative. Do you need a degree? No. The example that probably almost everybody gives is Marissa Tomei, right? Just remember, yeah? My Cousin Vinny. If you haven't seen it, rent it. It's a good movie. And Marissa Tomei gets up on the stand. She's not well educated at all, but she worked in her father's car repair shop. And the question had to do with tires on a car. And they get her up there, and she knows everything about every kind of car that ever existed. And she qualifies as an expert, even though she didn't even have a high school degree. So as long as you have the requisite knowledge or skill level, you don't have to have a degree to be an expert. We talked about that. Privileges, we talked about. Okay, purpose for which the evidence is offered. And once again, here's where that behemoth character really gets broken down. Because we've got impeachment, we've got non-hearsay state of mind, we've got mimic, notice, ownership or control, legally operative facts, truth of the matter asserted. So if we're talking about character evidence, once again, legally operative facts, elements of the cause of action. If you have a cause of action like defamation, where character is part of the prima facie case, injury to reputation, character comes in, right? Where else can character come in this equation? Impeachment, right? Reputation for truthfulness. And of course, when we get to truth of the matter asserted, now we want to maybe distinguish between criminal and civil. Generally speaking, evidence of good character to prove that someone acted in a good character way is not admissible in a civil proceeding, but in a criminal proceeding, who can bring in evidence of good character? The defendant can. Of course, if the defendant does, the defendant opens the door. But now you can see character coming in for the truth of the matter asserted if introduced by the defendant in a criminal proceeding.
Could you clarify, when they open the door, is that to all things, or is it limited to what they spoke about?
Right. So the witness who is testifying to the defendant's good character can now then be cross-examined on the matters that are in front, whatever that
like
person.
Non-violent,
right.
Violent, it can't be like, oh, he's a liar in this.
Yeah, right. If the witness doesn't testify about some other trait, then the door is not open to that trait. It's just open to the door is open to the trait that has been presented in evidence. Impeachment. There are a lot of different ways to impeach, right? And so remember there's so many different ways to impeach, and keep your eye on impeachment because you can use reputation or opinion in respect to truthfulness. You can impeach with prior convictions. You can impeach under the federal rules with bad acts, not under Florida rules, right? Bad acts in Florida can come in under mimic, but they can't come in for impeachment purposes. Question?
Yeah, I'm kind of confused between, like, convictions of that witness and then prior bad acts of that witness. What about prior bad acts of the defendant in Florida to impeach?
To impeach whom?
To impeach the witness. The witness is a reputation witness saying that he's a good
Can you?
guy,
How could?
we heard he was arrested yesterday.
You can't impeach somebody with evidence of somebody else's bad act, no matter what.
To show that he doesn't have knowledge of his reputation.
Oh, that's different. So it's not. You're impeaching. What's the word I'm looking for there? His veracity. You're impeaching the veracity of the witness. It's not a bad act. It's a different issue.
Right. But I'm bringing up the different
Okay. Yeah.
Like, have you heard that he was arrested yesterday, or have you heard?
Well,
this?
You can ask.
So that you don't know what you're talking about.
Well,
you haven't heard
because
that
you're
wife beater.
once again, though, you're attacking the veracity of the witness, right? Okay, so that's in Florida. Can you use a? Wow. I don't know. I don't know if the question is, can you ask somebody on the stand in Florida, have you heard that he beat his wife yesterday? That would be a bad act of the defendant, not the witness. My guess is no, but I honestly don't know. Certainly you can't use the bat. You can't say, isn't it true you beat your wife yesterday? You cannot ask that in Florida. That much I do know. But if you can bring it in, if it is strikingly similar, you can bring it in a criminal proceeding under mimic. Other things, prior inconsistent statements, of course, former testimony, not former testimony, but prior inconsistent statements you can use to impeach as well. Okay, let's talk about, see if there's anything else I want to raise there on. Not really. Bias is pretty obvious. Yeah, those are your different methods of impeaching. Do you want to take a minute with that list? Most of what you're going to see, certainly prior inconsistent statements, convictions, bad acts. And remember, with bad acts, if you ask somebody if they, under the federal rules, obviously, if you ask somebody if he or she committed the bad act, and the answer is no, you cannot use extrinsic evidence on the bad act. Opinion, reputation, both used under the federal rules, just reputation in Florida for impeachment. And there's your mimic rule. Don't forget about it. Remember, of course, that it is criminal only. Can't use it in civil proceedings.
You can't use it in civil.
Cannot. Mimic.
I've heard it both. Like I've been in lectures where I was told you could use it in civil also, and then I've heard
Wow.
like you can't.
Okay. The rule that I've learned, and I'm not going to say I'm an expert in evidence, but certainly the rule I learned is mimic is criminal only. I can look around a little bit and see if I find anything.
Like in our lecture,
Yeah.
that's what I was told. But then I've looked at the answer choices in MBE questions, and I've seen it where you could use it in civil. Has anybody else seen that? Or just I've heard it both ways.
Okay, there could be some kind of exception that I'm not aware of in terms of civil proceedings. That's always possible because, again, I don't teach evidence. I've got a pretty good knowledge of it, but I'm not an expert. Certainly the rule, the basic rule that you've all learned, the rule that I learned when I took evidence is that you use it in criminal only. If I can find something that explains it within a civil context, I'll certainly take a look.
Like in the rule, it says that it's permitted, and then it says, but in criminal cases, you have to put them on notice. That's the only difference. So it doesn't say that you can't use it.
Let me look at that a little bit more, and if I find something that I can send around, I will do that.
How would you prove intent for intentional battery without being able to break it?
Well, you don't use it, but it's not, you're talking about bad acts there. You have other evidence, other circumstantial evidence that you can use of intent. Okay. Truth of the matter. Even when you get to the truth of the matter asserted, don't go to hearsay. It's the last thing you want to think about because that's the least likely answer, which you probably figured out by now. It's usually not hearsay, no exception. And in real life, there's so many other ways to get evidence in. So this, in that respect, the exam mimics real life. So starting with an admission, which we know under the federal rules is admissible non-hearsay. It is a hearsay exception, of course, in Florida. Habit is not hearsay. Habit, you always do it, you never do it, something of that sort. If you have a prior inconsistent statement that's given under oath, it goes to the truth of the matter, but it's not hearsay. And as we mentioned before, evidence of good character in a criminal proceeding if introduced by the defendant. Again, it goes to the truth of the matter, but it's not considered to be hearsay.
One of the distinctions for habit in Florida, it says you can only use it to
Corroborate for personal habit.
So, I mean, what would be an example? I mean, aren't you always kind of corroborating something with habit?
Oftentimes you are, but it's not required under the federal rules. So under the federal rules, if all you've got is the habit evidence, then that's sufficient proof. In Florida, you need something as well as the habit evidence.
Well, what could be that something else, like somebody else testified?
Yeah, somebody else said, I saw him stop or not stop, right? Florida, yeah. Now, remember, the corroboration rule in Florida is for personal habit only. There's no corroboration requirement for business habit in Florida. Okay, hearsay categories. Remember, you want to distinguish between your unavailability requirement and hearsay in which unavailability is not required. The list for required unavailability is relatively short. Former testimony, dying declarations, declaration against interest, family history, and then you have that catch-all. We don't have any catch-all categories in Florida. For a dying declaration, under the federal rules, homicide and civil proceedings. Florida, it's criminal and civil. And unavailability now in the broad sense. You don't have to be dead. Declaration against interest, the most important thing there is to distinguish it from an admission. Because an admission is made by a party opponent. A declaration against interest is made by somebody who's not a party, who's not a party to the trial. Remember also, as people are writing, and I'm going to flip the stage, don't forget about hearsay within hearsay. If you have layers of hearsay, every layer has to satisfy the requirements.
Can you just say that again and distinguish what you said, declarations against interest?
Yeah. Declaration against interest is made by somebody who's not a party to the proceeding, not the plaintiff, not the defendant, it's third party out there. And admission is made by a party opponent, plaintiff or defendant.
Does that even apply to someone who hears, like a party?
Well, that's hearsay within hearsay. Then you've got to go through your layers.
Got to have both then?
Each layer has to be admissible.
For the double hearsay, for example, if we have a police report and we also have the statements of a third party making statements, when we do the double layer analysis, first we take out the document out of the hearsay exception, or we start with the statements that the third party said in there? I'm confused as to the process of the order of where we start.
Oh, yeah. Let me think for a second, because give me your example again.
Like a policing court, there's a correct.
Yeah.
Obviously, it's in the
Okay, so you got a police report which so and so said to the officer, and then the officer then said to his or put it in his report.
Right.
Okay. I would start with the so and so said to the officer first, and I'd establish whether that would be admissible, and then. So I guess I would go in chronological order, at least in the example you gave.
Because when you're trying to see whether those
Yeah.
statements come in, do you first receive the report comes in, or
No, I go with the first statement, the statement that was made to the officer that was then embodied in the report. Okay. Unavailability, immaterial. You got lots of categories there, and only a couple things I want to point out. When it comes to, where is it? Learned treatises over here. Learned treatises under the federal rules can be used as substance, and they can be used to impeach. If you're using a learned treatise as substance, which is this hearsay exception, of course, the witness has to be on the stand and the treatise is read into the record. You don't actually introduce the treatise itself. In Florida, you can use a learned treatise. And of course, with a learned treatise, the judge has to first determine that it's a reliable source. Don't forget about the judge the role of the judge as a gatekeeper in a lot of these cases. And that's a good gatekeeper example. So judge has to determine it's reliable, and then it's read into the record. Florida does not have this learned treatise exception. You can use a learned treatise to impeach in Florida, but not as substance. Anything else that I want to mention here?
It sounds silly, but we came across this question before. A dictionary is not a learned treatise. That's just something you take judicial notice of.
Right, correct. Yeah, because you're just a dictionary meaning, and a judge might take judicial notice of a dictionary meaning. A learned treatise is something that's going to give, you know, an exposition, an explanation on stuff. A dictionary just gives a quick definition. Here we have Convisor Mini Review. Learned treatise. The judge would have to decide if it's a reliable source of the law, and then it could be read into the record. You might not think it's a reliable source. I'll leave that to you, judges. Other questions on your hearsay exceptions? And last thing, actually, I do want to point it out just because we do have a difference in Florida. Your presumptions. There are two kinds of presumptions. Florida recognizes them both. Federal rule is just the bursting bubble. In most states, honestly, just the bursting bubble. So what's the difference? I'll give you two examples out of the Florida comments to the Florida rules of evidence, because they are good examples. With bursting bubble, remember that first of all, a presumption is based on an initial proof of an initial set of facts. And if you prove that base of facts, then you can presume an additional fact, which then shifts at least the burden of production to the other party. If it's bursting bubble, all that's shifted is the burden of production. And then if that person introduces enough evidence to get to the jury, that's all they have to do, then the bubble is burst and the burden of persuasion remains on the person who initially had it, which is usually the plaintiff. So here is an example. If the question is whether something was received, a letter, the person who has the burden on, the initial burden on receipt of the letter has to prove the following: that the letter was properly addressed, properly stamped, and properly put in the mail. 3 facts, right? From that base of 3 facts, we then raise a presumption, rebuttable presumption, but a presumption that it was received by the person to whom it was addressed. That's all you have to prove if you have that particular burden of production, is 3 things: properly addressed, properly stamped, properly put in the mail. Now you've produced enough evidence to get to the jury on that question of receipt of that letter. The other party now has the burden of production to produce enough evidence to get to the jury to dispute or to disprove that the letter was received. The ultimate burden of persuasion, who loses if the evidence is 50-50, remains on the person who was trying to prove receipt in the first place. That's bursting bubble. Burden of persuasion shifting is different because you shift both the burden of production and persuasion. The example that's given in the Florida rules is the presumption that arises when 2 persons participate in a marriage ceremony, even if the marriage ceremony is void. Because as soon as you produce evidence that that the 2 persons participated in the ceremony, both the burden of production and persuasion shift to the other party. And when you shift the burden of persuasion, that means that other party not only has to provide enough evidence to get to the jury, but also, if it's 50-50, that person now loses.
So that can, like, in effect, never happen in a criminal case, because then you're putting the burden on the defendant.
Yeah, and in Florida, remember, we do recognize both kinds. This burden of persuasion shifting presumption occurs only if it's done by statute. You have to actually have a statute that creates a shifting of the burden of persuasion. And where should you be on the lookout for it? In the area of wills and trusts. Because if you have someone who can prove a confidential relationship that gives rise to a presumption of undue influence in the execution of the will or the trust, both the burden of production and persuasion are shifted by statute. The statute expressly states it, to the proponent of the will, which means once you raise that presumption, the proponent's going to lose.
When we talk about like the defendant having to prove their defenses,
Yeah.
can you talk about that?
Right. Easier said than done, but I'll give you sort of a generality. The question is, if I'm understanding your question correctly, has to do with who has what burden. Plaintiff, if you're in a civil case, plaintiff is going to have the initial burden of production and the burden of persuasion on the prima facie case, the elements of the cause of action. And so too, of course, for the prosecution in a criminal proceeding. The defendant, especially in a civil proceeding, the defendant has the burden of production and persuasion on affirmative defenses. Affirmative defenses, those are the ones that you have to raise in your first pleading, or you lose them. Self-defense, for example, or comparative negligence, those types of defenses. So that, and in the criminal area, it gets a little more complicated, so I don't kind of want to not, yeah.
Because you can't.
Depend. Yeah.
They said like I had a question. They said it's a split according to the
That's
states.
the problem.
Some
Yeah.
states-
When you're talking about affirmative defenses, some states shift the burden to the defendant, but the burden of persuasion.
preponderance or something.
It's by the preponderance of the evidence usually for affirmative defenses in the criminal area. Some states put the burden of persuasion on the defendant, but others put the burden of production in respect to the affirmative defenses, like self-defense, on the defendant, but leave the burden of persuasion, disproving self-defense, on the prosecution. That's where the split is.
Is Florida like that?
I don't know what the Florida rule is, actually.
Okay.
Yeah, I don't. Okay, any other evidence questions? All right, yes, sir.
Confrontation clause hearsay.
Oh, yeah, confrontation clause hearsay goes to, I'm sorry, that category, where unavailability is immaterial. If your defendant, if your witness, if your declarant could be put on the stand and be confronted, then Crawford requires that the defendant be, that the witness actually be confronted directly. If you, go ahead.
So like in Florida for breathalyzer results and field sobriety tests, they can't admit it unless the cop testifies. The cop that conducted the test or whatever.
That's a different issue. Yeah. Okay. But the general Crawford is, and I wouldn't, honestly, you don't see Crawford coming up a lot in the questions. But the idea with Crawford is that if you have an out-of-court declaration, then the person against whom it's being offered has to have the opportunity to confront if that opportunity is available. So if you've got somebody who could be, if you've got a dead declarant, you can't cross-examine them anymore. But if you've got a declarant that you could bring into court, then you're supposed to do it.
What's the proper way to rehabilitate? Like, once, I guess I've been confused when they say like you have a motive to lie or fabricate versus, never mind.
No. Okay.
Disregard.
Yeah, anybody else on earplugs? Earplugs, going once, yeah.
Come on down.
Yeah. Let's put some over here. Oh, yeah, go ahead and put some over there. Okay. It is 4:45. There are lots of other topics we haven't covered. And let me ask this for those who are still standing. Is there something in particular that anybody wanted to talk about that I haven't covered yet? that can, that we can do, or is there a general topic that you want to do just an overview? Yes, sir. They could, but I don't think they will. If there's if they give a products liability question, which they easily could, the question that I did, the marina and manufacturer and all that, take a look at that packet, because I lay it out for you, and that's the formula that you want to use if you have a products liability case. And you could very easily get a products liability question. Could it be combined with med-mal? Yeah, but they usually don't. And under the circumstances today, I don't think so.
Whenever you do have a question like that, do you always cover, do you have to decide the intent, street liability or negligence, and then do always the warranties?
Right. In Florida, and we do things a little bit differently than some states do in respect to products liability. We allow pleading in the alternative. Some states don't. So what that means is if you get a products liability question, you got to cover all the different kinds of products liability theories. Products liability is the big umbrella. Underneath it, strict products liability, negligence products liability, warranty products liability, and fraud if necessary. I would start with strict products liability. Traditionally, that's where you start because you don't have to prove fault. So at least traditionally, it's the easiest to prove. Next, negligent, easiest to prove because you don't have to prove fault. So start with strict products liability. Then go next to negligence products liability, because while you have to prove fault, you don't have to worry about any privity of contract issues, which honestly you don't have to worry about very much with warranty either. But at least, again, traditionally, that's how it goes. So go strict products liability, then negligence products liability, then warranty products liability, and if the facts warrant it, a little bit of fraud.
I have a real property question. Do you think we really need to memorize all the dates for the notice for kicking out the tenants?
Oh.
Because there's so many in Florida.
Yeah. They actually test stuff like that, unfortunately, so you do the best you can with it. I will say this, that when it comes to landlord-tenant and what we call tenancies at will that are really periodic tenancies, it tends to be in the context of non-residential. So, if you're going to clutter your brain with some dates, maybe the non-residential more than the residential. A lot of times they test non-residential tenancies.
For a mortgage modification, I understand that they use priority to the extent of the modification, but if the modification is as to the interest rate or the term of the mortgage,
Right, depends, yeah.
How would I know?
Yeah. The question has to do with modification of mortgages in the context of priorities. So if you have a senior mortgage that's modified, the question is, does the part that's the modification, does it fall down, does it lose priority? And it depends. If that modification makes it easier for the mortgagor, for the borrower, to perform, so for example, an extension of the time period for payments, then the modification does not lose priority. But if it makes it more difficult, and when I say perform on other mortgages, the juniors. So for example, again, senior mortgage extends the payment date out much farther, which means that you've got a longer time to pay off the senior, more money to pay off the juniors. The modification of the senior stays at the top level. If the modification makes it more difficult for the mortgagor, the borrower, to pay off the other mortgages, then the modified portion loses priority. For example, an increase in the interest rate in the senior. The increase, whatever that increase is, 1%, 2%, that loses priority. So just look at the ability of the borrower to pay the other mortgages.
So when it loses its priority then, but if it stays on the property, though, like the senior mortgage stays on the property, does it stay on the property with that new modification?
Well, it does, but if you have a priorities issue and who gets paid first, the portion of that mortgage that retains its priority gets paid first, and then that other part gets paid later. That's what happens.
Under the title theory, the mortgagee is entitled to rents and profits.
Yes, traditional common law. It's true. The traditional common law, the mortgagee gets legal title right away, which means that rents and profits are supposed to. Now, does it really actually work that way in real life? No, but theoretically, yes.
But does those rents and profits, does that go to the debt that's actually being? It's just additional to that.
Because yeah, exactly. Okay, does anybody want to do another topic? I can, or do you want to hit the road? It's really up to you guys. Anybody have a burning desire to talk about anything else? Kevin?
You said that property would more likely be with commercial paper. So
Could be.
what type of fact pattern would you
A mortgage. Mortgage. Because a mortgage can be a negotiable instrument if it's drafted properly. So you'll have a mortgage that's transferred from mortgagee to a new person. Could be two. You could have several different issues there.
Can you just go quickly the prior bad acts evidence when you're trying to, not about convictions, just bad acts?
Uh-huh.
You're using it to impeach, like I guess you can't call a witness because that's extrinsic evidence. You can't do it.
You can't. You have a witness who's on the stand, and you're trying to impeach that witness with a bad act. And so you say to the witness, isn't it true? And it's got to be a bad act that goes to truthfulness, of course. You say to the witness, isn't it true that you forged a check last week? Not were you convicted, but did you forge a check? Because if were you convicted goes to convictions. So you say, isn't it true that you forged a check last week? If your witness says, no way, no how, you're done, right? If your witness is dumb enough to admit, then that's not. But you cannot use extra, because you couldn't then say, but the bank just, here's the teller who took the check from you. You can't do that.
You can't call in another witness because that counts.
Correct. That's extrinsic evidence. That's correct. And then, go ahead.
How we use negligence per se? A lot of them
Oh, sure. Negligence. Okay. Negligence per se, it's actually a really good question. So let's take a moment on negligence per se, because it shows up on both parts of the exam. So negligence per se is a procedural tool. And it creates, guess what, that presumption we were just talking about. A rebuttable presumption is just a bursting bubble presumption. You lay a layer of facts to raise a presumption of duty and breach. What's the layer of facts? First, you have to have a statute or ordinance or regulation of some type that's criminal in nature. Traffic ordinance will do. And in Florida, that's usually what you're going to see. And that statute, ordinance, regulation, whatever it is, the plaintiff is a member of the class that the regulation is designed to protect. And the harm that occurs to the plaintiff is the type of harm that the regulation was designed to protect against. If you have those three things, the criminal-like statute or ordinance, plaintiff as a member of the protected class, and harm that the statute was designed to protect against, you've laid that base with the three, and in majority rule anyway, and it is the rule in Florida, this much I do know, you raise a rebuttable presumption of duty and breach, no more. Just duty and breach. Res ipsa raises a rebuttable presumption of the entire prima facie case, but negligence per se, just duty and breach.
Is that true in Florida as well? It raises that rebuttable presumption?
Yep. Yeah, and again, case law specifically dealing with traffic accidents. It's a rebuttable presumption.
Although, joint and several liabilities are used, but it's still used in certain contexts. Do you know the context that we do?
Partnership.
Going back to Corinne's question with how does that interrelate with the evidence stuff? Because it reminded me there was a specific evidence question where a person was convicted of DUI, and then in the civil trial they tried to use the DUI, and I was assuming that it would come in as like a negligence per se type of thing, but it was not allowed in.
Right.
So I mean, how?
Right, because What would you use negligence?
Well, no, yeah, because a lot of the multiple choice questions, they have
Mm-hmm.
this violation, but then they're like, oh, it doesn't matter because he wasn't in the class. That's the answer sometimes, but sometimes that's not the answer. So I'm just trying to figure out where to use it.
Yeah, right. Your negligence, yeah, negligence per se, it's going to be a presumption question if it's an evidentiary question. What type of presumption is being raised? Because it is an evidentiary tool, but it's a tool that raises a rebuttable presumption. So it's back to what we had here. That's in evidence. Now, when you get to an essay in Florida, it's probably a little easier to spot and handle because it'll be in a tort essay, dealing with some kind of accident that occurs.
Okay. So in tort situation, how do you apportion fault if you're not sure who caused the injury? Or like if
Right.
the injury is aggravated.
Well, if I'm understanding your question correctly, remembering again that we no longer have joint and several liability in Florida, so each defendant is liable only up to the level of his or her relative fault. It will be up to the defendant to place the blame for a portion, whatever it is, on somebody who doesn't have to be a party to the lawsuit, who doesn't even have to be identified.
Okay.
Just some unnamed somebody. You can have a jury instruction that instructs as to some unnamed somebody who contributed. Anything else? Anybody else wants to talk about? What we might want to do now, because I know you guys are getting really tired and we've been going at it. I'll stay here as long as we need to. And if there are individual questions, which we're starting to get now, I can certainly answer your individual questions for as long as it takes to answer any of them. So with that in mind, I'm going to wish all the rest of you really good luck. And you can certainly, in the next couple of days, if you have questions, I'm sure there are some that are waiting for me that I haven't even looked at this afternoon. You can send me questions. I will try to answer them as quickly as I can. Question?
Yeah, I don't know if you had a chance to talk to the library staff about the YouTube videos.
Yeah, here's the problem with the videos. Apparently, there's a problem on the Lexus end, and we aren't. Kerline was trying to get them loaded, and she was unable to because of a glitch in Lexus. She wasn't able to get them up. They could be up now. I didn't have a chance to ask her when she just walked in, but we're working on it.
They put them on YouTube, though.
Yeah, but I don't know whether you can get to them through. They're not open to the general public, and they are.
Yeah, it's a channel. It's like Dean Singer's
Yeah, right,
channel or
right.
something. It's on YouTube.
Yeah, it is on YouTube, but if you've got the link, I don't. Yeah.
Your materials are on the Lexus
Yeah.
platform now, but YouTube.
Right. The link was Alexa's problem. But if you want to just go directly to YouTube through the channel, you can do that.